Good
Morning. We are back on the record. The time is 8:30 a.m. and the date is Friday, May 15th, 2026. The commission and its staff are again appearing from the commission's Bollinger Room in Helena, Montana. This is day 4 of the scheduled public hearing in docket 2025.10.078 involving the joint application of Black Hills Corporation, Northwestern Corporation, and Northwestern Energy Group for approval of merger. To begin the day, I will first ask for public comment. Please note that this session is being recorded and all comments received will be public records, so please do not include confidential or private information in your comments. To ensure that we can get 2 witnesses and through our scheduled business today, we have established a 30-minute, up to a 30-minute period for public comment this morning, and we have 8 public commenters that have signed up. So that's about 3-4 minutes apiece. Will keep us on schedule. And by a show of hand, do we have any public commenters in the room this morning? Okay, seeing none in the room. I think they're all the ones we have recorded or registered or signed up to testify online. We will begin with the commenters online since there's none in the room. And when you're called on, please state your name, spell your last name for the record, and the town, and please state the town where you live. We do not need your physical address, just the town. If you are speaking on behalf of an organization, especially if one is a party to this proceeding, please identify the organization. And if you have written comments, please submit them online through the Commission's Ready portal or by emailing them to pschelp@mt.gov. All right, and we will now move to our first registered online commenter, Karen Kirk. Are you here? Not seeing Miss Kirk. We will move to Bruce Lottie. Bruce Lottie, are you here? I see there you are.
I am here. Good morning.
Morning.
My name is Bruce Lottie. It's Lahti, and I live just south of Great Falls, Montana. And I'm concerned this morning because I have just recently, on March 17th, entered into a small generator interconnect agreement with Northwestern Energy for a new solar project at my property. And I'm concerned that those agreements continue to be upheld in whatever this new organization is, whether it is Northwestern Energy or Black Hills Corporation. I know there's got to be quite a number of us that have established solar through a net metering agreement with Northwestern Energy. And although the agreement is a 10-year agreement, it does not specifically state that it's one-to-one net metering, although that's how mine is set up currently. And I would like to make sure that that continues in whatever form this new organization takes. That would be the sum total of my comments at this point.
Thank you, Mr. Lottie. And just to note, I think I skipped this over in my opening remarks, but we have present in the Bollinger Room Commissioners Molnar, Bukacek, Commission President Jeff Wellborn, and myself, Jennifer Fielder. I'm the presiding officer for the hearing. Commissioner Kanochi is absent. All right, Miss Kirk, Karen Kirk, are you available?
Yes, I'm available. Good morning.
Good morning. And Mr. Lottie, you might want to mute yourself if you're staying online. Good morning, Miss Lottie. Go ahead.
Good morning, commissioners. My name is Karen Kirk, which is spelled Kirk, and I represent Montanans for Affordable Energy. And I really appreciate you making time for the public to weigh in on this docket because this merger feels a bit like a battle between everyday people versus giant companies that are seeking even more power over their captive customers. As I'm sure you're aware, many in Montana are in the grips of an affordability crisis as the cost of living is spiking much faster than our wages, making our economic situation more and more untenable and unbalanced. And energy is one of those expenses that is relatively inelastic. That is, people can't easily cut back because that would mean deciding between, for example, driving to work versus heating your home. And both of those are pretty essential to people's lives. Energy prices, as you know, are baked into the cake of everyday life, for better or worse. But a theme that I've heard in the public comments this week is that regular people are urging you not to approve this merger while business interests are eager for it. And I think that right there is pretty insightful. That should tell us something. Corporations are becoming larger, more powerful, and more manipulative over people's lives. And the theme in today's national mood is that people are getting tired of this. They're very wary of being under the thumb of ever larger companies. But this is only made possible by a government that repeatedly sides with the companies and against the will of the people. This merger will create an even bigger company that is even less interested in the lives of Montanans. And this merger really is about data centers, and we've heard a lot about that. And data centers, it's incredible to watch what's happening with public opinion. They're about the least popular thing in America. And the bipartisan worry and fear and just impatience for data centers is kind of amazing to watch in our very polarized society. People are pretty unified on this topic. And Northwestern Energy says one thing in public and in press releases, but quite another thing when they speak to their investors and their shareholders. And there's a lot to be seen there in that disconnect. And we plainly hear Brian Bird every time he promises those investors that this is really about data centers. And this has been quoted, we're really going to capture data center opportunities. And that's a legitimate fear of regular Montanans. And to make it worse, we can't know what that means, right? Because the details are deliberately hidden from the public. And that I find to be really problematic. At a bare minimum, the public needs to see these details. This affects our lives. You have the power to bring more transparency to all of these transactions, and I urge you to do so. And I also urge you to give the voice of the people more weight. People are being stretched to the breaking point, and having an even larger, more detached, less caring company that forces us to be their customers, that's just a bold move in the wrong direction. So please insist on more transparency for Montanans and do not approve this merger until all of us can know the details. Thank you very much for making time for a comment. I really appreciate it.
Thank you. And next, public commenter, Caitlin Pisurcia.
Hello. Good morning, commissioners. Thank you for the opportunity to comment today. My name is Caitlin Pisurcia, spelled Caitlin, last name Piserchia. I'm calling in from Missoula on behalf of the Montana chapter of the Sierra Club and our thousands of members and supporters across the state. We are asking that commissioners deny the request for the merger with Black Hills Energy at this time. And many of our concerns have already been mentioned in this room, including the concern that Montanans will lose control over many of the energy decisions and energy assets that impact our lives. We believe that the Montana Public Service Commission should continue to have real power in assessing and holding Montana's largest monopoly utilities accountable for reliable, affordable power that's in the public interest of Montanans. And I'll reiterate that there are many unanswered questions that make approving a merger imprudent, including the complete lack of transparency about the impact of the 11 or more data centers Northwestern Energy is in conversation with. As CEO Brian Bird has acknowledged, this merger is motivated, at least in part, by Northwestern Energy's interest in large-scale data centers. We think Montanans deserve to know how they'll be impacted by a boom in new data centers before commissioners approve this merger. As Northwestern Energy CFO Crystal Lail has said, Northwestern Energy has not studied the rate impacts of the merger on residential customers. We think Montanans deserve to know how they'll be impacted before commissioners approve this merger. It's not a secret that data centers have ballooned energy and water usage nationwide, along with electric bills in the last couple of years, with very few long-term local jobs to show for it. Water quantity, electric load, and affordable electric bills are all already substantial concerns in Montana, as well as water quality. Northwestern Energy seems to be doing a lot of speculation about how the merger would help Montana and not nearly enough due diligence in investigating and sharing with the public what we could expect. And Montanans deserve due diligence on all of these fronts, including much more proactive planning to mitigate the impacts of significant energy transitions that may result from a merger. So we ask for a no vote from the commission at this time. Thank you.
Thank you. Next, we have Tracy Isley. Is Tracy Isley online? Not seeing Tracy Isley. We will go to Amy Seelenberg.
Yes, I'm here. Can you hear me?
Yes, we can. Go ahead.
Thank you. It's Amy Sillenberg. That last name is Cilimburg, and I am the Executive Director of Climate Smart Missoula, so here in Missoula. And our organization follows this PSC proceedings, in general over the last bunch of years as we assist residents and businesses with affordable electricity options. We are not a party to this particular proceeding, though, so thank you for allowing comment, including virtual, and for your careful consideration of this merger. We primarily request that you folks just slow down and not decide on this merger until we get the answers needed to make a really informed and protective decision regarding how we Montanans pay for our energy. As you've heard and as you understand and know, the data center issues are front and center. We, have asked for a new rate class and protective tariff classes that could be developed that could really protect us as consumers and captive ratepayer. There's also things that have come up at this hearings of assets at Colstrip, potential harms or benefits to us that could that have been brought to the fore given these proceedings these last bunch of days. As Ms. Trinnell has astutely offered, there are many, many questions that still need to be studied and answered. And I believe that we Montanans and ratepayers of Northwestern deserve such considerations and transparency. So please just slow down, and the due diligence is really valued, and we very much appreciate that. Thank you.
Thank you. Abby Huseth.
Yes, good morning. Can you all hear me?
Yes, go ahead.
My name is Abby Huseth. Last name is Huseth, and I live here in Missoula with my family. Thank you for the opportunity to give my comment this morning, commissioners. I am echoing really what a lot of other commenters have had to say this week, particularly regarding transparency around this transaction. And I want to thank those, including Ms. Trinnell, and others who've really been pushing for answers. That's feels like the minimum that we as Montanans and ratepayers deserve. We know that the last time that Montana went through an energy company reorganization with the Montana power debacle, we really got screwed and lost control of our assets, which we then had to buy back again. And we just don't want a repeat of any kind of situation like that. With this merger, it's concerning on a number of levels. We're certainly going to be a pretty small fish in a big pond with this large company that's formed, and I share the concerns that others have shared. The leadership of Northwestern Energy stands to profit millions from this, but I'm really wondering what the actual benefit to ratepayers is. It's been very unclear. I also share concerns around data centers. There's major problems with these across the country, and you kind of have to be living under a rock to not see, as Ms. Kirk mentioned, how unified opposition has been to these hyperscale facilities. And they've been stopped left and right. So I really wonder before we speed ahead with these opportunities and this boom, we need to make sure that we're not also going to suffer the consequences of a bust very soon. There's just too much we don't know, especially around data centers and what that looks like. And at this point, it just feels like caution is the right answer, and we shouldn't be speeding ahead without a really clear understanding of risks to the public, around resources, but also particularly ratepayers in terms of impacts to energy costs. And in this case, we'll deal with that later is a pretty unacceptable answer. We need answers now as far as the impacts of those large data centers on the grid and the merger in general on ratepayers that are currently under Northwestern. So I'm asking today that you please say no to this merger at this point. Like others have said, we need more time to know more information. It seems like this has been in the plans for a while, and then all of a sudden now here we are speeding through with it. We need to slow down and do our due diligence and really ensure that this isn't going to have major negative impacts on ratepayers and the public in our state long-term going forward. So thank you for hearing my comment this morning. I hope you use your role and as protectors of the public and really stand up and make sure we're getting the answers we need before this huge change that could affect so many of us. Thank you.
Thank you. Next, we have Katie Thompson. Is Katie Thompson online? Not seeing Katie Thompson present. We will go to Kristen Walser.
Good morning. Can you hear me?
Yes, go ahead.
Great, thank you. My name's Kristen Walser, Walser. I'm from Bozeman and representing myself. I'm commenting as a concerned ratepayer of Northwestern Energy. And thank you for holding this public comment session. I am asking you, the PSC commissioners, to reject this merger until you and the public have more information. With Northwestern having a minority status on the proposed board, I'm concerned that the PSC and Montana customers will have less control over which jobs are cut to produce the projected 36 million in reduced wages, how and when Colstrip is decommissioned, whether Bright Horizons will join a regional organization of Western Energy or the Southern Power Pool to participate in regional transmission planning, community-centered data center development is another issue, and whether the data centers will have a separate rate class or pay all the costs and pay all the costs assigned to that class. So there are a lot of major decisions affecting Montana family bills and businesses bills, and we all need low cost and reliable energy. These are questions that should be asked before the merger, not after. And my concern is, how will our PSC be able to exert control over this gigantic company? Northwestern recently, in the last couple of years, built a natural gas peaker plant, which, according to Lazard's levelized cost of energy, is the most expensive kind of energy generation there is, even above nuclear energy. And our rates have suffered immensely in the past 3 years. So how can we find out whether the Black Hills merger is going to continue in that same way of building the most expensive energy generation versus looking at options? So if you were going to grant the merger, it would be interesting or valuable, I think, to get some performance assurances. And I'm not sure if a quick decision will aid in that. So thanks so much for accepting this testimony, and I hope you consider all of these ideas that you've heard today. Thank you.
Thank you, Ms. Walser. We will circle back to Tracy Isley. Is Tracy Isley here? And just note that Commissioner Pinocci has entered the room at 8:51. Is Katie Thompson online? Katie Thompson. All right. Seeing no further commenters online, are there any commenters in the room? Are there any commenters in the room? Okay, and no other commenters have registered to speak, and seeing none in the room and no further online, we can now move into the evidentiary portion of resume the evidentiary portion of our hearing. Do any of the parties have any informal questions before we resume the evidentiary hearing today? The schedule that I have planned is to have MCC present their case in chief this morning. We had scheduled their witness, Ralph Smith, to join us this morning. And then we will move to 350 Montana's case in chief. Okay, with that, Mr. Brown, are you ready to proceed?
I am, Madam Chair. Got my coffee here. Thank you. I appreciate the opportunity, Commissioners, to make an opening statement. I guess I want to slow down a little bit and take the time needed to just kind of, I guess, support this settlement is my message to you all today, because it's a reasonable outcome in my view and of the issues in this case. But first of all, I just wanted to thank you for accommodating Mr. Smith. I believe he attended a child's graduation yesterday, so he has listened into most of the hearings so far, but you should be aware that there may be parts of yesterday that he has not yet watched. Let me make sure I'm on the right page here. So like I said, the message of my opening, the takeaway is that the settlement is a reasonable outcome of the contested issues in this case. And when I talk about the settlement, I'm talking about the one between obviously the joint applicants, the LCG, and the MCC. I want to just say a couple things about settlements, because we can't ever expect, I don't think any of us ever expect a settlement outcome to check every box that we would check if we were king. I think the parties feel the same way. That's the nature of settlements, is you don't get everything you want. And if you think of the outcomes in these regulatory cases as trying to fall within a range of reasonableness, sometimes that's pretty narrow, sometimes it can be broader. It's unlikely a settlement's ever going to land exactly where really anyone would have it land if it was just up to them. But I would say this settlement does fall within the range of reasonableness for outcome in this case. And I don't want to speak for all settling parties, but in addition to parties kind of keeping their powder dry and being able to, not concede the principle or even often specific dollar amounts or issues in specific cases, we're able to raise these issues again. And I think a lot of the issues that we've talked about over the past few days are being addressed and will be addressed in other dockets. Another consideration, of course, and you might think of small water dockets when I talk about this, but is, reducing regulatory costs and just the costs of getting these rates changed normally. This is not a rate-making case, but just the cost of this whole process to try to reduce that. In these kind of cases with the larger utilities, it's definitely money well spent. I don't mean to overstate that, because the cost of the commission and the MCC are a very small fraction of the cost of service, even though the cost of all this is in the rates and recoverable. I remember Jim Payne, some of you might remember him, telling me after my first electric supply tracker docket when I first started at the commission, where I went on for quite a while, had a lot of questions at that time, still do. But he reminded me, if you add up the total costs of everybody in the room, while this brand new, very novice commission lawyer is taking quite a bit of time to clarify a lot of things, if you added all that up, how much that costs, just to keep that in mind, because he said, I think he thought it was good cross, but I did take up quite a bit of the hearing time. And later, Dennis Lopatch, who some of you might know, would joke about how we never really learn anything on cross, and cross can be kind of, I think, frustrating for everyone involved, to the extent it's not always, it doesn't always discover the most information or facts about a case. It's not always the best way to get at the truth. Anyway, settlements are designed to promote efficiency, and I think there's a lot of incentives the commission should consider that are at play when it comes to settlements. Generally, settlements are encouraged under law, just like in court. And here we are in a quasi-judicial setting, so it's quasi, but I still think that there's a lot of value in settlements for a lot of reasons. And one consideration, I think, I imagine, of all the parties who settle, is to reduce this commission's workload, because there are other dockets and matters pending and coming down the pike, and we all have limited bandwidth. So whenever we have a hearing on a settlement, the hope is always that it makes everyone's life easier. Not saying that's always the case, but that's certainly one of the goals of settlement. I think in this case, for the commission's consideration of this settlement, it's important to keep in mind that the benchmark for that should be the status quo we have today, which is after the reorg docket we had a few years ago. And so whenever anyone's thinking or talking about what this transaction will change going forward compared to the status quo, make sure you're considering the post-reorg corporate structure, where we now have a parent company since then. The Puget share has come up. That's a lot of these issues that we've talked about are true today, and they will continue to be true and exist as issues after this. The actual entities and the scope of this commission's jurisdiction and Montana's regulation is not changing. In fact, the entities aren't even changing, again, from the reorg. And so I think that should be the benchmark for trying to decide how big of a deal or how impactful this particular transaction will be. We're not in a pre-org world anymore. You got to look at the structure that was approved there, the ring fencing, and what could or couldn't be done now under that newish structure compared to what is going to be true going forward. And if you look at that org chart attached to the stipulation, what's outlined there as subject to Montana jurisdiction is not changing. This commission's regulatory authority over those entities is not changing. And I would submit that, again, some of the issues at least with coal strip and data centers are issues today, and they will continue to be issues after this, whether this is approved or not. Also, I would say, and this probably won't make me popular with some, but that rate making and our job as regulators of regulated utilities is not about creating jobs. It shouldn't be about creating jobs. You wouldn't want to build costs into your base rates on which the rest of the economy is built. I would say those stable, predictable, reasonable rates are kind of the foundation for all other economic activity. So I don't think it's appropriate to look at this industry, this regulated industry, and these basic services and the provision of these services as drivers of economic growth. And my job, at least, is not to generate tax revenue for the state, or create or maintain jobs if it doesn't make sense to do so. Of course, I'm sympathetic, but when it comes to the rate making and the incentives that we're trying to maintain for regulated utilities, and really the cost of service is key. I think we should keep our eye on that ball. It's about keeping the lights on, safe and reliable service at just and reasonable rates. And this is not a rate-making docket. I think that's easy to forget because that's usually what we're doing. And I would even say that it's actually not this commission's job to balance interests. Again, in a quasi-judicial kind of, foot in both worlds situation we live in my opinion, I don't love it when people talk about balancing the interests of the utility and consumers. This isn't a courtroom. Doing nothing is usually not an option, or I guess you could at least say that deciding to do nothing is a decision. And so your job is to price these services at just and reasonable rates, which means that the rates are reflective of the actual cost of service. And to incentivize the provision of safe and reliable service over time. And I think the way you do that is through the rates generally. And so, we get utility requests. It's the utility's job to manage the system, manage their financial health, and decide when they need to change the price of their commodity. And when you get one of those, you have to decide whether to approve it or whether to approve it with conditions by a preponderance of the evidence through these proceedings based on a lot of technical expertise, which is unlike a court, I think, not just in the room here, but amongst yourselves and staff, and the burden of proof. And that's what should dictate approval, or what your approval looks like, and not some kind of splitting the baby, just balancing interests. You have to make positive findings. So, I think you have some very specific jobs, and it's to make sure that service can be provided and the utility has the ability to maintain the system and keep the lights on, and that the incentives are in place for them to do that in the most cost-effective way over time. I should have numbered these pages, Madam Chair. So in that context, which is, highly technical, and it's, there's a reason that this job of setting the price for these services and, overseeing what is a for-profit company, a private enterprise, in this context, I think, transparency is not always a good unto itself. In fact, sometimes it's not. And regardless of what you think about that, it's been dictated by the Great Falls Tribune case for many years now. The Montana Supreme Court has set forth a very specific process and set of standards for us to either protect certain information or not from public disclosure. And so, again, anyway, transparency, I hope that the commission, the public understands that where I sit, and given the goals of, I think that, frankly, the goals that a lot of the parties in the room actually share, which is maintaining rates and services, and my job is to maintain those in the interest of the consuming public collectively. Disclosure of certain information that affects the cost of service can actually be detrimental to consumers' interests. I think the Montana Supreme Court recognized that. And transparency and disclosure are really just one of many considerations that I consider in achieving those goals. And my focus has been and will remain the outcomes of these cases, not the process or procedure. And I think this attitude is consistent with very old but still very current case law regarding how regulation is supposed to happen, how agencies like this at both the federal and the state level are supposed to, how you're supposed to get to just and reasonable rates. And the truth is that courts won't reverse state or federal rate-making decisions, even if the methodology may be flawed. They really do look at the outcome. Excuse me. So I think that these cases should be judged by the outcome and not by kind of just transparency for transparency's sake, or some kind of popularity contest with what is really a very technical subject matter that is available to anyone who wants to dig into it. So I think it's for good reason. And again, this is a for-profit company. That profit motive is there to hopefully have them provide this service in the most efficient, effective way possible. We're trying to simulate competition where there's almost no transparency a lot of the time. I think data centers might be a good example of that, actually. So again, it's a little perhaps awkward for me to say this, especially on the record. But I think the value of transparency in and of itself, which is a pretty vague term, in a sausage factory, for example, can often be overrated. And especially if that sausage is palatable enough, doesn't make you sick. And similarly, in practice, even in Montana, where we have strong open government and right-to-know laws, but even here, that whole issue of open government and the public's right to know is also dictated by very specific statutes and case law that's been developed over the years. It's not a black and white issue, for good reason. And the legislature and the courts have tried to strike a balance, under our Constitution. And I'm not here saying they've gotten it exactly right, but the point is that it seems to me like this commission's making a good faith effort to follow those procedures and laws which apply to all state agencies. And I can understand frustration from folks who aren't parties to the case and don't have access to everything. But, I don't think those are issues that started with this docket. And I don't think throwing terms around like, black box or closed door or transparency are really that helpful. I think it can quickly become just kind of an argument without substance, given, the actual issues here, like the legal standards for mergers and acquisitions and the actual conditions that were agreed to, which really have not been discussed much at this hearing, but I think are very important here. In addition to aliens, of course, when it comes to disclosure. I will try to wrap this up, Madam Chair. At this point, I'm sure we'll get back into the weeds and all the parts per million in briefing. But I just wanted to suggest with briefing, and I have not discussed this with council, so I apologize to them. Just a suggestion, but I guess I'll go ahead and, on the record, suggest that the parties have discussed dates, but that the opening brief be from the joint applicants in support of all the settlements that they've signed, and that the response brief be from 350 Montana and Montana Farmers Union, and then that the reply briefs be from all settling parties who were part of a settlement, including, obviously, joint applicants. I think just given the what's actually contested at this point, that might make more sense. And again, I believe we have dates for that, but have the opening brief from joint applicants, the response from the interveners who haven't settled, and then reply briefs from everyone who's settled and the joint applicants. Again, just a suggestion to consider. You know, the way we do this and these services, the idea is for everyone to share in both the burdens and the benefits of this. These services, which are supposed to be, you know, universally available at some specified level of quality, where the characteristics of that service are specified in tariffs, and based on the cost of service. And these are issues that, you know, we have to deal with and consider in an ongoing way. You know, I think constantly refreshing forecasts. I think there's a number of dockets again where the issues you've heard a lot about are going to be addressed, and I don't think this merger is going to change or resolve those either way. So the settlements, is an approval of the merger with certain conditions, which are very important. And I would encourage the commission to look closely at those conditions and try to decide if it's within the range of reasonableness as an outcome here to resolve this request. So with that, Madam Chair, I feel like I lost one of my pages, but that's probably for the best, given it's day 4. So with that, I will call Ralph Smith. And again, thank you for accommodating his remote appearance, and thank you for letting me appear remotely as well. Mr. Smith, can you hear me?
Yes, I can.
Thank you.
Excellent.
I believe I need to swear in the witness.
Yes, please.
Yes, thank you. Raise your right hand. And Mr. Smith, do you swear to tell the truth and the whole truth, nothing but the truth?
Yes, I do.
Thank you.
Let's see here. Mr. Smith, you have seen most of the hearing, but part yesterday, there's parts you haven't seen. Is that correct?
I was able to catch most of it the first 2 days. Yesterday, I had to leave around 1:30-ish Eastern.
Okay. And if there was a issue, I think that's going to come up this morning, but about an NOL response, an updated response to a data request, is that something you can address if you're asked about it? NOLs?
I'm aware of the updated response on NOLs, yes.
Okay. And were you involved internally with our office in throughout the settlement discussions in this case?
Yes, I was.
And you filed testimony in support of the settlement between the joint applicants, LCG and MCC?
Yes, I did.
And that, if approved, would result in approval of the transaction, but subject to certain conditions?
Yes, the settlement includes a number of conditions.
Okay. And approval of the transaction, again, subject to those conditions?
Correct.
And if I were to ask you today whether you believe, based on everything you've learned throughout this case about this transaction, as it's been presented to the commission, that the settlement's a reasonable compromise and resolution to the issues in this case, would you agree, yes or no?
Yes.
Okay, and I believe we've marked the 3 sets of testimony from Mr. Smith as MCC 1 being his initial intervener testimony, MCC 2 is his supplemental testimony, and MCC 3 is his testimony in support of the settlement. Does that sound right? And those would, okay, and those would be labeled MCC 1, 2, and 3, respectively?
Yes.
Okay. And do you have those available in front of you?
I do.
And do they appear, are those true and correct copies of what you filed and have said in this case?
Yes, they are.
And if I were to ask you the same questions there under oath today, would your answers be the same?
Yes, they would.
Do you have any changes to make to your pre-filed testimonies?
No.
Okay, with that, I would move for the admission of MCC 1, Mr. Smith's initial testimony, MCC 2, his supplemental testimony, and MCC 3, his settlement testimony.
Are there any objections? Hearing none, MCC 1, MCC 2, and MCC 3 are admitted.
Thank you, Madam Chair. Mr. Smith's available for cross and redirect.
Thank you. Is there a cross-examination for this witness?
A little bit. Thanks, Madam.
Ms. Trudeau.
Thank you, Madam Chair. Good morning, Mr. Smith. I am Monica Trinnell, and I represent 350 Montana. How are you this morning?
Doing well, thanks.
So I just wanted to ask you a couple of questions on your settlement. So just to give everybody where we are in context, the total settlement was $10 million for Montana, correct?
That's the amount of the bill credit. That is correct, and that is part of the settlement.
And do you agree with, I believe it was Northwestern's witness, Crystal Lale, calculated that at about $18 per household? Do you agree with that number roughly?
Yeah, that's roughly, I agree with that, yes.
Okay, and that's
Madam
per
Chair,
household.
I don't mean to object, just to clarify that it's per service per household.
That's what I was going to ask next.
Right, per service household, per residentials. Some of the other
Thank you.
classes indicated they didn't need it, so we agreed that it should all go to residential customers.
Okay. And are you aware of the joint applicants, the only number that is in the record to date, their range of quantifiable net benefits was 48 to 70 million? Are you aware of that number, Mr. Smith?
I think that was in MCC 2. A lot of that detail was confidential, but I think that's the high level estimate, correct?
So thank you for clarifying. So that's the public number is 48 to 70 million, correct?
Yeah, and keep in mind that that's across the entire combined organization. That's not the Northwestern Montana utility number.
Was there a specific Montana number to your knowledge?
In my supplemental testimony, after reviewing the joint applicant's due diligence documentation, I calculated a recommended credit of about $28 per customer.
Okay, I'm not talking about the credit that you recommended. I'm talking about the joint applicants, the number that they quantified as a net benefit. And I wanted to just stick with that public 48 to 70 million dollar range. That's what you understand to be the public number.
I believe that might have been the public number. Again, all the details behind that were in the confidential documentation.
Okay.
And you keep in mind that that's the combined system-wide number.
Right.
So you have to try to compare apples to apples.
Right. So there was a different number in the confidential, without saying what it is, there was a different number in the confidential information, correct?
There was a range, and I believe the range is what you just indicated.
Okay. And would you agree with me that as the joint applicants are here today trying to get this commission to approve this merger, they would put the highest possible number that they are saying the net benefits would be to the customers in the public setting in front of this commission? Would you agree with that in principle?
Not necessarily. I think the estimate was actually made by an advisor to the joint applicants.
Okay.
Whenever we've tried to get that information out of them, and we did that in fairly extensive discovery, they responded pretty consistently that they're in the very early stages of integration planning, and they didn't offer up any other number that they had any confidence in. So I don't believe they're trying to overstate the estimated synergies.
Okay.
I've seen no evidence to the effect that they're trying to overstate the estimated synergies.
Okay, thank you. So as we sit here today, the record evidence shows us that the highest possible number that the joint applicants have put in front of the commission that could be a benefit, a quantifiable benefit, is $70 million. Do you agree with that?
I think that's the highest number that pertains to the overall estimate of combined company synergy savings.
Thank you. And then would you agree with me that the $10 million credit that you negotiated in the settlement is a cost to achieve the benefits of the merger? Would you agree with that?
No, I
Madam
would absolutely.
Chairman, Madam Chair, I'm just going to object at this point that this seems to be getting into confidential settlement discussions, which should not be admissible. The $10 million number is a compromise number that is part of a whole package of terms and conditions. And so for Ms. Trinnell to try to tie that 10 million figure to something in the record, I think is an effort to, pry into how the parties, what the parties discussed in settlement, and that number should, it's certainly within a record and a range of numbers, but to try to back out of that number, how to calculate that doesn't seem appropriate.
Mr. No, I'm simply asking if that's a cost to achieve. I have no interest in their settlement discussions.
I think
I'm sorry, a cost to achieve what?
My question to the witness is, starting with the 70 million, is the $10 million credit, would the witness consider that a cost to achieve the merger benefit of 70 million? I'm just trying to do a math problem here.
No, I think you have it backwards, Council. I think the 70 million was
Mr.
before
Smith,
cost to
Mr.
achieve.
Smith, stop.
Yes.
There's an objection, and I have not dispensed of it yet. So, Counselor Brown, with the rephrase on that question, do you still have an objection?
I'll hold off for now. I think perhaps I just don't understand the question, but I'll withdraw for now.
I'll withdraw my question, Madam Chair, and I will move on.
Okay,
Thank you.
thank you.
Mr. Smith, starting with the $70 million, which is the maximum possible merger benefit that the joint applicants have put in the record, would you agree with me that the banker's fees in analyzing this transaction, regardless of who pays, the banker fees should be deducted from the cost from the total value?
I'm not sure I agree with that. I think the
Okay.
banker's fees are part of the transaction costs, and the settlement provides that none of that will be charged to ratepayers.
I
And
understand.
Those estimates of the synergies is called, those are the synergy benefits, and that would typically be either before or after transition costs or cost to achieve. So I think those are different concepts,
Okay.
different categories of costs.
So just to be clear, and so we have accurate evidence in the record, is it your position that if the ratepayers don't have to pay the costs, it isn't considered a cost to achieve the benefits of the merger? Is that your position?
Not really. There's different categories of costs, and these are discussed in my testimony. Okay, there's transaction costs, which
Right.
are costs that they incur to try to get the transaction done.
Right.
And then there's transition costs and synergy benefits and costs to achieve.
Right.
Those are costs to basically integrate the two systems, see if there's any savings that can be achieved by combining functions, etc.
Right.
And so there's a high level estimate of potential synergy benefits. The estimate that we've been referring to, the 70 million, is before cost to achieve, and the company's made that pretty clear in some of the rebuttal. And
Right.
it's also clear from the confidential information that was derived from. So the net synergy benefits after the cost to achieve are going to be something lower than that.
Right. And that's what I'm trying to get to. So, and just to give this context for the commission, the justification for a merger from the applicant's presentation to this commission has been operational efficiencies, correct?
It's not really. That wasn't one of their main reasons for doing it. I think they're looking at being bigger, having better access to capital, because they are two groups of regulated utilities. There ought to be some savings there that once they integrate, they can achieve.
But that has not been quantified in this record in front of this commission, right?
There's some estimates in my MCC2 testimony, and if you especially look at the confidential version of that, there's some detail behind it.
And that is all factored into this $70 million net benefit or total synergy benefits, yes?
Again, the 70 million was an early estimate by an advisor to the joint applicants
Right.
of combined company synergy benefits before cost to achieve.
Right.
Just to
So,
be clear.
right. So thank you. Okay. So would you agree with me that transition costs would count as a cost to achieve?
I would.
Okay. Thank you.
And very importantly, we've got in the settlement agreement that all transition costs up through the date of consummation of the merger are going to be borne by shareholders, and none of those will be charged to Montana ratepayers. And that's a very important provision in the settlement.
Right.
And it basically relates back to the fact that the joint applicant shareholders are at risk for those costs until the transaction is consummated.
Until
So any
transaction.
transition costs up through that date are being borne by shareholders. Montana ratepayers are being protected from having to bear any of those costs.
Right. So thank you for that clarification. So there is a hard stop. Let's just pick a random date for purposes of understanding and clarity. Let's say September 1. All costs, if that's the date the transaction is finalized, pursuant to your settlement, everything before September 1 would go to shareholders and everything after that would go to the ratepayers. Yes?
No, everything before the merger consummation date is clearly stated in the settlement that those costs will be borne by shareholders. None of those will be charged to Montana utility ratepayers. Transition costs after the merger is fully consummated will be subject to detailed review in the Montana Utilities next rate case. So that doesn't mean they're going to get any of those costs.
Okay.
They're going to have to show that those costs are producing net benefits, and the settlement requires fairly detailed accounting to be maintained and presented in the first rate case of the Montana Utilities after merger consummation.
Okay.
So they're still at risk for potentially not recovering those. It'll be dependent on what the facts show in the subsequent rate cases.
But they're entitled to ask for them, yes?
They would be entitled to ask for those, but they're also required to present details on those costs and on the savings that have resulted from incurring those costs.
Thank you. Thank you, Mr. Smith. And I believe it was in your testimony, or maybe it was in some responses to data requests, you did not address in your settlement, your analysis, how Colstrip is treated, did you?
It's my understanding that the treatment of Colstrip is being addressed in other.
My question, Mr. Smith, please listen. My question is, you didn't address the treatment of Colstrip, did you?
We didn't specifically call out
Thank
Colstrip
you.
in the recommended conditions.
Thank you.
Madam Chair, I would just request that the witness be allowed to finish his answers without being interrupted by counsel.
Sustained. We do want to hear the Montana Consumer Council's witness testimony, Mr. Nell.
Thank you. And I would just ask that my questions, which are specific and narrow, be specifically answered. Mr. Smith, your settlement was filed prior to the filing of the large load tariff, correct?
The large load tariff, I'm not sure I understand the question. Are you talking about the tariff that was filed in a different docket before the commission?
Yes. Your settlement testimony was filed prior to that large load tariff filing coming in at the commission, correct?
I believe that's
know?
correct. Yeah,
Okay.
that's being addressed in a different docket, and
Okay.
the MCC has consultants on board to look at that in detail.
Okay. And the IRP, you were also, your settlement, it doesn't address that either, right?
The settlement doesn't specifically call out the IRP. It does provide for comparisons between capital expenditures that had been budgeted and actuals.
Thank you. Mr. Smith, I believe that are you prepared to answer a question about the NOLs? I do have just one for you.
I guess I'll have to hear the question first.
Okay, that's fair. Yeah. Okay, sorry. On the NOLs, are you aware, or is it, do you understand that their value is between $200 and $400 million? Does that sound accurate? Have you had a chance to look at the information that has come in? And
What were the numbers again?
200 to 400 million in value.
Which NOLs are you talking about specifically? Because I think Black Hills had some and
Right.
Northwestern Corporation had some, and so which one are you
Northwestern. So I'm talking about the value of the NOLs to Northwestern. So what they bring to this transaction in value is approximately, as I understand it, 800. And I will admit that I'm not an accountant. So if I'm not asking this question well, I apologize. But what I guess let's just get to the root of the matter, which is the NOLs have value. Would you agree with that?
Madam Chair, if council's looking or referring to something in the record, if she could identify that, I think it might be helpful for the witness.
I think I rephrased my question, Madam Chair. And my question that's before the witness is, do you agree that the NOLs have value, the net operating losses, that they have value?
It's my understanding that NOLs carry forwards can be used to offset taxable income in a particular year up to 80% of the taxable income in that year.
And are you aware that Northwestern is carrying significant net operating losses today that they bring to this transaction? Do you understand that to be true?
That's my understanding, that Northwestern does have some net operating loss carry forwards that they have available.
And when we're looking at the ledger of benefit and harm that has been quantified in dollars, did you factor in the value of the NOLs in your calculation of benefit and harm?
The NOLs will typically be addressed in a subsequent rate case in the context of looking at the utilities' detailed calculations of income tax expense. Northwestern has taken some fairly aggressive tax positions on repairs deductions, on expensing of AMI meters, etc. And those are associated with the Northwestern electric utility. And those are typically reviewed in detail in the context of their rate cases. There are a bunch of Internal Revenue Code normalization rules that apply to some of this stuff, particularly as it pertains to any portion of the NOLs that result from the use of accelerated federal income tax depreciation. And those
So-
have to be considered as well. But
Okay, so
we didn't view that as a source of harm, and that all the accumulated deferred income taxes are not being affected by the proposed transaction. And this is the way NOLs interact with the other income tax calculations. Has to take into account normalization requirements. And that's an issue for review in the utility rate cases.
So I think I'm following you, and what I want to be clear about for the commission and its assessment of whether or not this merger causes harm or is a net benefit or is in the public interest. Everything that you just said about how those would be treated would be true with or without the merger. Is that accurate?
That's accurate, and especially in the context of this particular merger, which is an exchange of common stock of the two joint applicant holding companies. One thing we look at very closely in all utility mergers is the impact on income taxes and deferred income tax expense and accumulated deferred income tax expense, which can be a large rate base offset for the utilities in the context of their rate cases.
Okay.
So this was an item that was on our radar screen. We did look at it. And the accumulated deferred income taxes, which would include the NOL carry forwards for Northwestern,
Okay.
are being carried forward intact without any liquidation or diminishment as a result of this proposed transaction.
Okay, but just to be clear that if the merger doesn't happen, all of that treatment about the NOLs remains with Northwestern Energy Group, and the benefits that we just discussed inure to the credit and the benefit of Montanans, correct? Without the merger, everything that you just talked about stays with Montana and Northwestern Energy Group, correct?
Without the merger or with the merger, all the NOLs that are related to the Montana utilities will stay with the Montana utilities.
Madam Chair, I am trying to get a very narrow line of questions here and explain what's happening. So I'm asking, and if the witness could just be directed to answer the question so we can develop the record here more clearly.
That's fair. Mr. Smith, just try to be concise with your answers, please.
So without the merger, all of those NOL benefits, all of those tax credits, they stay as they are today with Northwestern Energy Group that it serves primarily Montana, correct?
Madam Chair, I think we could use a little clarification because there's Black Hills NOLs that are referenced in the data request that was updated, and then there's Northwestern NOLs. So which excuse me, sorry, which NOLs are we asking about?
Mr. Nell.
I was clear in my earlier question, Mr. Smith. I am talking about Northwestern's current NOLs that are held by Northwestern Group. And I understand that there are two different corporate entities here with NOLs within Northwestern, sticking with where we are today, no merger. The NOLs have value, and those NOLs remain with Northwestern as we sit here today, and they stay with the Montana system, correct?
And that will be the case with or without the merger, is my understanding.
Okay. Well, so with the merger, those NOLs continue to exist, but who takes the benefit of them changes, yes?
No, those are related to the Montana utility operations. They're
And
accounted
Montana,
for under the uniform system of accounts, and they remain with the utilities that generated the related tax deductions.
for rate making purposes, correct?
Correct.
And that is a subsidiary then of Black Hills Parent Corporation, correct? Post-merger,
Of Bright Horizons, ultimately the new parent company.
right. And Bright Horizons, the parent company, will decide who gets the value of those NOLs and where they go post-merger, correct?
No, that's not correct. Those will stay with the Montana regulated utilities and will be factored into the calculation of income taxes in the Montana utility rate cases,
That's
similar
for
to how they have been prior to the merger.
yes, I understand. And that's for rate making purposes. Yes, what you're talking about is rate making, correct?
Rate making and accounting under the uniform system of accounts.
Right. But the NOLs, the net operating losses, can flow up to the parent company and they can use those basically like cash post merger in a way that they can't today, correct?
I'm not really seeing that since Black Hills currently has a substantial amount of NOL carry forwards as well.
So I'm not asking
I'm
whether
not
they will
seeing
or
that.
not.
I
I'm
mean, it's,
asking whether they can.
they have to have taxable income in order to
Right.
utilize the NOL carry
Right.
forwards. And to the extent they're able to monetize any of those more quickly under the new organizational structure, that benefit should be captured and accounted for, so that if any of the Montana regulated utility NOL carry forwards are monetized more rapidly as a result of the consummation of the merger, those benefits should be accounted for and provided back to the Montana utility ratepayers in an appropriate manner in the utility's next rate case.
And if they do that, then Mr. Smith, if they monetize them more quickly, then the cash doesn't flow down to the subs, does it?
If they monetize them more quickly, the utility that provided the NOL that's being monetized would obtain a benefit from that.
If the parent company
And,
decides to
and
do
I,
that,
I,
yes?
I should also point out conversely, if the result of the business combination results in the Montana utilities not being able to monetize their NOL carry forwards due to the new structure, that's also something that's going to be looked at in detail in their rate cases. And that might entail a need for a potential adjustment to their income
Right,
tax expense.
right.
But
So
as we stand now, all the deferred income taxes on the utilities books are being preserved. They're not going to be affected at all by the proposed merger.
I understand that. The question, Mr. Smith, really is quite simple, and it's who stands to gain from that? That changes, correct?
The Montana utility ratepayers stand to gain if the NOLs can be used more rapidly, and they will be protected if the new structure results in them not being able to be monetized as quickly, because that'll be looked at in the rate cases. And that's an item that's on our agenda. We look at that in detail in every single Montana utility rate case. And if we find out that's the situation, we will be recommending adjustments so that Montana ratepayers are not harmed by the new corporate organizational structure, resulting in them not being able to monetize their own utility NOLs as quickly as they would otherwise have had the opportunity
All
to monetize those.
all to be decided in the future, yes?
Deferred income taxes are always reviewed in the context of a utility rate case.
Thank you. Thank you. I don't have any further questions, Madam Chair. Thank you.
Okay, thank you. Are there any commission questions for this witness? Commissioner Pinocci?
Thank you, Madam Chair. So we're going to get right to it. Now, I'm going to apologize. Your direct testimony, I'm on page hearing binder 745. So this paperwork I have doesn't have a page number on it other than in red, hearing binder 745. Can you go to that page for me? And the question, in case
Madam Chair, Commissioner Pinocci, I don't believe Mr. Smith has although correct me if I'm wrong, Ralph, but it might be better to refer to the page and the document as it's filed before the commission. I'm not sure we have the binders.
Yeah, I don't have the Bates numbered pages. I have the,
How about I read the question? We'll see if that helps. Have the joint applicants quantified anticipated amounts of such savings? And what I'm reading here is, while the joint applicants have not yet identified specific categories or amounts for potential merger savings at this stage, as noted, now I do, and I think I've identified some savings. Can we talk a little bit about that?
yeah, I guess I'd like to find the page so I can understand the context of the question. Because there a numbered page number on it that I
Yeah.
can refer to?
It says here, hearing binder 745, and this is the first time I've had any paperwork that identified it like this. I apologize.
Madam Chair, if I just might offer,
Go ahead.
I believe that's on the 29th page of the direct testimony filed by Mr. Smith. The question begins on line 9.
Is it line 9, Commissioner Pinochi?
Yes, now on line 11, your response starts with no. Now, that really surprises me because I've been hearing day after day how there's great benefits of the merger. But when asked about savings on line 11, you just say no. The response states no specific categories for savings have not yet been identified. How can I hear about the benefits for days, and when we come to this question, your response is no? What are your thoughts there?
Yeah, I think, are you referring to my direct testimony that was filed on February 9th, Commissioner Pinochi?
Yes, and let's take a moment to allow the witness to get his testimony in front of him.
Yeah, I think if you're referring to my direct testimony that was filed on February 9th, if you recall how the proceeding developed, that was before we got access to any of the confidential information. And I believe that all of the related quantifications and information related to the joint applicant's expected synergy savings was included in the confidential information. And that definitely is addressed in my additional direct testimony that was filed on March 13th. But as of the February 9th, I don't believe we had any of that yet at that point in time.
Let me practice a couple ideas with you that I think where there's some savings, because I do think there's some benefit to the merger. For instance, there's 2 management teams with the 2 companies. After they merge, there'll be 1 management team, which should save millions of dollars because you got 1 CEO and 1 vice president and so on. And that savings will be every year, not just 1 year, right? Because both
Right, yeah, that is one of the areas of savings.
30 year, right? Now,
Right.
Commissioner, slow down for a minute. Let's let him answer that question and then go on to your next one.
I wasn't done asking the question. Sorry.
Commissioner, you said right. That's a question. Allow the witness to answer, and then you may continue. Just slow down a little
All right,
bit.
I'll try to do better. All right, so another savings idea would be, let's say, mailing out the bills every month, right? You got 350,000 customers with 1 company, and they have their own mail shop and equipment to send out the monthly billing. Now the 2 companies will have, 1 area to send out all the billing. So in the end of the year, that's got to save, like $1 million. What are your thoughts there?
I definitely agree with that there should be savings in the combining the executive management. There should be savings in the board of directors area. In terms of mailing the bills out, I'm not sure that would be a big area for savings. Perhaps more savings could occur as customers migrate to having their bills emailed. That the emailing of the bills or getting them electronically, that not only saves the mailing cost, but it also saves the printing cost. It seems to me like that's probably a better area for savings. I didn't, in what I looked at, I didn't see any savings in like bill processing and mailing just from combining the two companies. But if they convert to more emailed bills and um, that could result in significant savings.
All right, let me practice a little more here. And I don't know if this is a possibility, but I'm trying to identify savings. Let's say there was a building that handled the printing and the direct mailing of the monthly billing, and each company had their own building. Now they can take out one of those buildings. They won't need the staff, and one building will handle all of the monthly billing. The duplication examples, we could go on quite a bit. For instance, there could be an office building that has 50 employees in it, and the other company has an office building of 50 employees, and now we only need one office building of 50 employees. So I think the duplication could be millions of dollars a year, right?
Yeah, consolidating functions, making them more efficient, eliminating duplication certainly provides an opportunity in which the joint applicants can investigate and probably realize some savings.
I would think that would have been in the discussion, but it sounds like that nobody sat down to really add that up, or am I wrong?
I think what they have at this point is they don't have a fully detailed integration plan. What they have at this point are high-level estimates of areas in which savings could occur, and that's based on various information, other utility mergers, typical transactions, areas that are subject to consolidation, like the executive management and the board of directors. So at some point, they will have developed a very detailed merger consolidation plan. And that's where I think you'll start to see the specific areas, like you've been mentioning, that they believe they can achieve savings in more detail than what's currently available.
The two companies must have identified a mutual benefit to do the merger. They must have sat down and said, wow, we can be more profitable. We'll be able to serve the customer better. But I do believe that the stockholders must have said, you know what, we'll make more money and we'll be we'll be better together. Now I'm thinking that you might have identified, if that's the case, could we have a lower rate to the ratepayer? Maybe a little bit. Did you think about that? And was that discussed any time in your work on this merger?
Yeah, we did definitely look at that. I mean, our first item was to prevent harm to Montana utility ratepayers. And then our second item was to see if there was some tangible benefit that the transaction would provide to Montana utility ratepayers. Up until we got access to the confidential information, it was really hard to get a handle on what the joint applicants were seeing as their potential merger savings. Once we got the access to the confidential information, we looked through that, came up with a quantified recommendation, recognized at that point that it was primarily based on very high level estimates. And the numbers we were working with at that point were combined company wide estimates that were provided to joint applicants by one of their advisors of the potential savings that they could bring out of their respective operations once they were consolidated. Once we got the confidential information, we did make a recommendation about getting some of those benefits to ratepayers in a very quantifiable and meaningful way, not just hoping that they would be realized somewhere down the line in the future. And there may be more benefits in the future if they're able to further consolidate and eliminate duplication and become more efficient. But for the purpose of this case, we used the information we had. We quantified a recommendation. That was the numbers that we were looking at that point, I think, were before any cost to achieve. So we thought the company came back in the rebuttal and said, look, these are before cost to achieve. So we were able to negotiate a solid number that's going to be a bill rate credit to Montana ratepayers. And so that's something tangible that we have in this merger settlement. And if they're able to further achieve efficiency improvements, that will be information that will be reported and quantified and available for review in the Montana Utilities next rate case. And that'll be reviewed in detail at that point, possibly with the benefit of additional savings.
I want to tell you that one of the challenges I have is the ratepayer is reaching out with me with just countless emails. My phone voicemail is full, and I get calls clear till midnight or whatever, trying to say, Randy, bring this concern out and this concern out. So I'm trying to apply those questions to you, and that can be frustrating for you. And sometimes council gets frustrated because you get off track, but you're trying to represent the public. Now, one of the questions that came up was this: which company benefits more from the merger? Let me give some background on that. What's very exciting for Northwestern Energy, and I'm very proud of them right now, is this interconnection that's coming from North Dakota to Colstrip. This is going to be a big business to be able to send electrons both ways. Also, we got a connection from the eastern United States to the western United States, a very exciting time. Also, they got a greater share of Colstrip, basically for nothing, and I think it's worth like $300 million more. So who benefited more from the merger? Black Hills, because of all this exciting opportunities in front of them? Or do you think that it's vice versa? And was that anywhere in your testimony? And I think it's important to the ratepayer that they know who benefited more in the merger. Did that come up anytime?
Yeah, I don't think we tried to assess, it looks like the merger would be beneficial to both entities, both of the joint applicants. We didn't try to, say one's getting 51% and the other's getting 49 or anything like that. But it looked to us like it could be mutually beneficial.
Okay, that's a good answer. All right, let's go to hearing binder 733. What do you conclude regarding the proposed transaction? Now, this sounds real important because based on the information provided to date, which does not include confidential information, benefits, risk for Montana and utility ratepayers, and therefore should not be approved without requiring additional conditions. Did you get these additional conditions?
I believe so. Yeah. If you're looking at the February 9th testimony, at that point, we weren't convinced that the merger was really in the public interest. There weren't sufficient conditions in our estimation to protect Montana ratepayers. There was no tangible benefit either. But if you look at the way our testimony evolved, we believe that the settlement that was agreed upon by the joint applicants, the LCG, and the Montana Consumer Council, it has sufficient conditions to protect Montana ratepayers. It incorporates the ring fencing conditions that were already in place, and it results in a good resolution of this, the matter at hand in this proceeding. So we do now recommend that the commission approve the transaction as provided for in the settlement agreement.
The reason this is an important question for me to drag out is because people want to hear that there was some scrutiny and that there were some good answers to that, and now you feel comfortable. So this demonstrates you had concerns, and those concerns have been addressed. Is that fair for me to say that you agree with those concerns being met then? Is that what I'm hearing?
That's what you're hearing. Yes. Yeah, we did definitely have concerns, especially in the first round of testimony. We pursued information diligently. We believe the concerns that were raised in my initial testimony, in my supplemental direct, and some of the concerns that were raised by the large customer group testimony as well, have now been incorporated into the settlement agreement. So there was a lot of analysis, a lot of diligence, a lot of effort that went into reviewing this proposed transaction. And we jointly conclude, I guess, with the LCG and the joint applicants, that the settlement agreement is a good resolution of this matter.
Are you concerned that maybe more of the management will be overseen outside the state of Montana than inside the state of Montana? And again, I believe, and of course, naturally, I'm going to be proud of Northwest Energy, and I really don't know Black Hills. I may be proud of them if I knew more about them. But does it concern you, and did it come up in your testimony that there will be more management outside of the state of Montana than inside the state, especially with the concerns of record growth in Montana? Any concerns there?
We were looking at, the combination of these two public utility holding companies. Their management seemed to be fairly similar. Montana, I believe, is still going to be the largest and most important state, single most important state within the combined operation. It's our understanding that Northwestern's current CEO is going to be the first CEO of the combined company. We think that Montana is going to be a very important state to the combined company, and that it will continue to get appropriate resources and management attention allocated to it.
Do you think this commission should be looking at this question more carefully? Are you satisfied that most of the company being represented out of state is okay?
Well, I think it's probably okay, and keep in mind they're currently kind of being represented out of state. I mean, the headquarters, the ultimate parent company headquarters, is in South Dakota. So, you already have a situation where you have a holding company, you have a utility, the Montana utility, and the corporate reorganization was effectively structurally separated from the South Dakota and Nebraska utility operations. And there's some ring fencing in place, which remains to continue that. So this is it's an expansion of a corporate structure that's similar to what you already have in Northwestern Group and Northwestern Energy. So that wasn't really setting off a lot of alarm bells for us. I mean, and I've been involved in a lot of other merger situations that involve either leveraged buyouts, which definitely raise alarm bells, acquisition of U.S. regulated utilities by foreign entities, which raises alarm bells, and other types of weirdly structured transactions. Sometimes, so we look for all that kind of stuff, and that's not what's happening here. This is basically a stock exchange between holding companies of two regulated utility entities. They're regulated utilities. Again, these are not like huge operations. I think they're trying to get a little bit bigger to better attract capital. When you look at what's been going on in the utility industry in the U.S., there's been a lot of business combinations, and there's some really huge entities out there that Northwestern and Black Hills have been competing for access to capital. Even with the combined company, they're still not going to be one of the largest electric utilities in in the country in terms of assets, revenue, sales, that sort of thing. You know, they do have a pretty large service area, but it's primarily you know, smaller cities and towns and stuff. You know, they're not like a utility that serves, you know, in New York City or Los Angeles or Chicago or Philadelphia. You know, so their service territories are fairly similar. And the structure of the transaction as a exchange of stock between the two existing holding companies and their shareholders. It seemed like this is a relatively low risk form of utility merger transaction in comparison with a bunch of other ones that we've seen that had much higher risk factors.
I want you to keep in mind that what you said is absolutely correct, that, you know, South Dakota, that's kind of where the leadership is. But most of my time here, Bob Rowe represented Northwestern, lived here in Montana, and would call me and say, wow, we have an outage, or call me and say, you know, we have a fire. And I don't have that connection that I used to. But most of my time here, I did have that leadership here in Montana and not South Dakota. Thank you for your answers. And to those people that are asking me questions, I think we dealt with a lot of answers to those concerns. Thank you. And thank you, Madam Chair.
Any other commissioner questions? Mr. Molnar.
Thank you, Madam Chair. Good morning, Mr. Smith.
Morning.
I don't have as many questions as Commissioner Pinocci did, and they're a bit more general. He's probably doing the best job of any commissioner on this, and actually digging in to the files and coming up with great questions. One of the things that came up, and I'd like to have you answer this, is Commissioner Pinocci has asked this in several days in several ways, and that is, why won't there be a rate reduction if indeed all these costs go down? Would that be because things that are rate-based, like Colstrip Unit 4, that stays the same no matter what your profits are? Cost of coal, natural gas as fuel stays the same no matter what happens in the merger. But the savings he was talking about is fewer people, close a warehouse, fewer high-level, high-dollar executives. Would those savings not be realized by the holding company and actually perhaps used to acquire more assets, build a gas generation plant to serve an area, that sort of thing, so that savings really don't flow down, they're kept up, and that they are dispersed, and they're quite possibly dispersed from there?
Well, I think there's a few things to unpack there. First of all, we're not really resetting rates in this particular proceeding. This is, you know, a request for approval of a business combination. It's not a rate case, so we're not setting rates and adjusting them either upwards or downwards. Having said that, we do have a quantifiable benefit now that's going to be available to Montana utility residential ratepayers. So that is meaningful, and it provides kind of like an advance on in a form of a tangible dollar amount on some of the savings that have been estimated. So the rest of your question, I think, goes to how they do their integrated resource planning. And that, again, I think is the focus of different proceedings, not particularly this one. And none of that's really changing in terms of the Montana Public Service Commission regulation of Northwestern Energy in terms of its rate setting process, in terms of its integrated resource planning, in terms of review of various items that come up in other proceedings before the commission. So the focus of this proceeding is basically on whether this proposed business combination should be approved, or should be approved only with specified conditions, or should not be approved. And based on everything we've seen in this proceeding, with the specified conditions that are contained in the settlement agreement, That enables us to recommend that the commission approve this.
Well, I understand that the question might go outside of our scope, but the question remains of customer benefit. And from my perspective, tell me if I'm wrong, you said that we have this new quantifiable asset, and I'm not quite sure what that is. Maybe you can get to that in a moment. But our tracker takes care of fuel costs, not affected by the merger. You're not going to buy more or less gas as Northwestern Energy. Same thing with coal. Everything that is rate based, or hydro, Coal Strip 4, Yellowstone gas plant, etc. None of that changes. So any synergies and savings that are going to happen wouldn't necessarily go to those things. It would go up to Energy Bright Future, or whatever they're calling it. Is that not correct?
That's correct to some extent, but we also have requirements in the settlement agreement for Northwestern to quantify, track, and report that information so it's available for review in their next rate case.
Okay, you know more about this than I. I've been at this for a while, but I'm not a quick study. I wind up with more questions than answers. So you have a settlement agreement, and several of the others have settlement agreements. I'm assuming they, interlock pretty well. How does that wind up in our final order? What if we don't accept it?
Well, I think you do have several settlement agreements in front of you. Our focus has been primarily on the one between the joint applicants, the LCG and the MCC. We do recommend that you approve that one. I guess on the others, you'll just have to look at them on their own merits and decide whether they're beneficial or not, and decide whether to approve those or not.
Okay, and that goes to probably my biggest question. I'm a bit more of a curmudgeon than Commissioner Panucci on this, because I've been through a lot of turmoil as a commissioner. Everything that I'm hearing on this from the utilities that are involved and the interveners that are wanting to settle, etc., paints a very, very rosy picture. We're going to get a better deal on shipping and timing for shipping. We're going to get a better deal on lines of credit. We're going, which, as you pointed out, and I think you're right, this is still a very small utility. Even combined, all of their customers come to about a suburb, a small suburb. But I've looked at an awful lot and lived through an awful lot of very, very rosy scenarios. And the amount you're offering for the risk of having our default supplier not under PSC control, working in an 8-state area, you're saying that the people are bought off, or that their compensation for that risk is $18. Can you tell me how you came up with the idea that the risk is compensated by a one-time payment of $18 per family?
Well, the $18 is, I wouldn't consider that a risk. I mean, I consider that to be a net benefit, a tangible net benefit to the Montana residential utility ratepayers. When you're talking about the items of risk, first of all, we're talking about this transaction is going to create a fairly large amount of goodwill. We have safeguards in to prevent that goodwill from being recorded on the books of any of the Montana utilities, from ever being charged to any of the ratepayers of the Montana utilities. The transaction involves fairly large amounts of transaction costs. Those are going to be entirely borne by the shareholders of the joint applicants, not by any Montana regulated utility ratepayers. In terms of transition costs, they're starting to incur those. And up through the date of the merger consummation, those are all going to be on the shareholder's dime. None of those costs will be charged to Montana utility ratepayers. So we've tried to identify a number of these significant potential cost risks and prevent those from being a problem for Montana utility ratepayers. As you pointed out, and as the joint applicants have, pounded the table fairly extensively, there are a number of identified benefits that they expect to receive out of the proposed transaction. Some of those will probably be achieved. Others may be a little bit more doubtful. It does make the combined entity bigger, but not by any means as big as some of the other electric utility conglomerates that are currently existing in the United States, for which these companies are competing with for access to capital. So I think the settlement agreement, at least from my perspective, strikes the right balance in terms of identifying and mitigating risks to Montana ratepayers, recognizing and providing opportunities for the joint applicants to combine and achieve benefits. And then it also provides some tangible, quantifiable benefit in the terms of the $10 million Montana Residential Ratepayer Fund. It continues the existing ring fencing that has been developed over a number of years, and that was updated in the Northwestern Holding Company docket. So I mean, from my perspective, it checks off all the boxes that I would be looking at as a commissioner for approval.
Thank you for that. Let me give you a few examples that had really good safeguards and had quantifiable estimated benefits. The old Northwestern, certainly not the people that are here before us, became the default supplier after Montana Power, with some really good information went into telecom, and within a year they couldn't even make their retirement payments. They were bankrupt. 2 years after Northwestern became our default supplier, and the press heralded that from one end to the other, they were bankrupt, wound up buying all of our assets again. 2007, nationally, the economy for real estate was go for it, invest everything, borrow money. 2008, everybody lost everything. There was so much focus on possible and probable that the facts as to who was holding what in the way of trash bonds became the facts of the matter. Deregulation in California was supposed to be the deal. It almost crushed Montana in 2001, and we're a long ways from there. On and on and on the list goes. And for $18, we're supposed to say, as the quantifiable benefit, which I believe is how you're looking at it, for Montana ratepayers, we should relinquish our control of our default supplier once again. I'm not seeing it. Using the examples I gave, all of which had the same safeguard you're talking about, can you tell me why we should be accepting high-level estimates, which quite possibly are very self-serving, sir?
Yeah, Commissioner Molnar, you're taking me back through memory lane here. I was involved in several of those, and they were some very serious fiascos. The California attempt to deregulate their electric utilities was an absolute disaster. That's not what we're looking at here. And the previous history with Montana Power, I know that was reviewed extensively in the context of the corporate reorganization. We actually dug up quite a bit of the detail of that in the bankruptcy proceeding and the safeguards that were put in place after the bankruptcy as a result of the bankruptcy. So we are kind of familiar with that history, and that's not really what we're looking at here. There are definitely some cautionary tales out there about, either regulatory regimes that were very ill-conceived and resulted in problems. Utilities that ran into financial trouble. There's been a relatively limited history of those. That's not really what we're looking at here. But I know once you've lived through that stuff, it does become an important point of reference. I've been doing utility rate analysis since approximately 1981. And I've seen a lot of this stuff myself. I've been involved in a number of the cases. We were involved in the California electric deregulation fiasco as witnesses in some of those cases. We've been involved in quite a few of these utility mergers and acquisition cases, some of which had much higher risk factors attached to them than this proposed transaction. We've actually been involved in some utility bankruptcy proceedings since approximately 2015. We've been advisors to the Puerto Rico Energy Bureau. In 2017, they had basically 2 hurricanes, including a Category 4, that absolutely trashed their electric system. They've been insolvent or in bankruptcy from that point, and they're still in bankruptcy. All of their utility plant additions are either being funded by federal emergency funds or by current year revenue requirement payments charged to the ratepayers. It's a real mess, and we've been trying to help them work through those situations and make progress to having reliable electricity at reasonable rates. So I'm familiar, I think, with most of the, bad situations that you described. We lived through the financial crisis of the worldwide financial crisis. That had a big impact on utility access to financing. I think actually this business combination will probably help the combined company get through something like that if it ever happens again. Hopefully it won't. People have hopefully learned. But a lot of the dire disaster type situations that you ticked off and that I'm also familiar with, that's not really what we're looking at here with this proposed transaction.
Thank you, Madam Chair. Mr. Smith, I think this will be my last one, but you've used the same words today that I've been hearing for the last 4 days, 3 days anyway, 3.5. Hopefully, I feel we've learned. We are supposed to, sir, I don't know if you're aware of our internal policy manuals and our court mandates and all the stuff that kind of define who we are and what we can do. But our votes, for example, in FERC, is supposed to vote on testimony, fact, and law. We don't have that here. We have fact and law. In the last 4 days, you've heard all of it, except for when you were at your graduation, which I hope it went well. I don't know if it was high school or college, but there's always exciting times. What facts have you heard that I can hang my hat on? What fact? Because frankly, sir, and I'll let you answer that in a second, we think we can get better financial rates. Still,
okay. Yeah, I do appreciate you letting me have yesterday afternoon off to go. It was my daughter's college graduation.
Yeah. Okay. Well, congratulations to her.
But yeah, the facts, I think, you've had testimony and an application filed by the.
One at a time, gentlemen. Commissioner, I think you did ask the question, what facts? So let's let him answer that.
Yes. I apologize, Mr. Smith. Can you please answer the facts?
I'll try to briefly run through the facts as quickly as I can. Basically, you had an application and testimony by the joint applicants. They had several witnesses. You've had testimony by myself. I filed 3 testimonies in this docket. each containing facts and recommendations based on evidence that's in the record. You had testimony by large customer group witness Mike Gorman. He's a very respected analyst. I have highest respect for Mike. You heard his testimony here. He's also recommended that the commission adopt the settlement. You've had a round of rebuttal by the joint applicants. You have probably literally thousands and thousands of pages of discovery information in the docket, which I understand most of it's becoming part of the record of the docket. There's a bunch of additional information that was marked confidential. That's also, I think, being made part of the record of the docket. So I think you have abundant facts on which to base your decision. Nobody's, the recommendations are based on identification of the risks that this proposed transaction potentially presents to Montana utility ratepayers, mitigating and alleviating those risks in a fairly foolproof and airtight manner, continuing the ring fencing conditions that protect the Montana utilities from potential implications of financing activities that go on in the other parts of the organization. And you do have on top of all that, the cherry on top of the cake, the $10 million residential ratepayer fund. So it's not like we're just doing everything and recommending approval only for that residential ratepayer benefit. But that is on top of everything else that we've already achieved in the concessions that were made by the joint applicants that are embedded in the settlement agreement.
I feel like making a statement, but I'm supposed to be asking questions. So
That's correct.
I'm going to try and get this into a question, sir. You said the facts were that certain experts had testified. I'm interested in the facts that they were alluding to, not the fact that they testified. My previous examples all came from the failed outcome of the testimony of experts. I'm looking for something a bit more specific. When utilities go from this size to that size, they get 0.5% better purchasing power, financial power. I'm looking for facts, not statements, and I'm not finding them. Can you please help me with that?
Yeah, the facts of this particular transaction are that it's an exchange of stock between the common stock shareholders of two utility holding companies. That's the basic facts of the transaction. There's facts that every single risk to Montana ratepayers that was identifiable related to this proposed transaction has been mitigated in a fairly airtight manner in the settlement agreement and the concessions that we were able to get out of the joint applicants. So as I see it, those are the key and important facts.
Thank you, Mr. Smith, and congratulations to your daughter.
Other commissioner questions? Well, Mr. Smith, you covered a lot of ground here today, and in reviewing your written testimony, your pre-filed testimony, and then what's been stated here today, I don't have any additional questions for you. So with that, does council have any questions for this witness? I think we may. If you'll hold on for just a moment. No. Okay. Good. We are then back to recross base on commission questions. And if no recross, okay, great. Redirect, Mr. Brown.
Madam Chair, I have no redirect, so I just want to thank Mr. Smith for his pre-filed testimony, his testimony today, and ask that he be permanently excused.
Thank you, Mr. Smith. Without objection, you are permanently excused.
And with that, MCC rests. And thank you to the commission.
Thank you, Mr. Brown. Okay, with that, I think we're ready for a little break, and then we will turn to Montana 350's case in chief. Miss, was,
I thought the calling of Ms. Leo was going to be in rebuttal to your examination of your experts.
I think we could do it that way. I have very short questions, so for her. So
what's your timing?
Madam Chair, Ms. Lael is online currently and can be available at the pleasure of the commission or later this afternoon. I understand her schedule has been cleared.
here's how I would propose going forward, if we may. Given that we're asking about information that came in on May 11th and that we had explicitly reserved the option of doing some live rebuttal, I would propose having Ms. Lael get on, asking her about the NOLs, and then if things come up that we need to address, allowing Ms. Bodell the opportunity to do that. And if the joint applicants need to recall Ms. Lael and their case in chief for their final rebuttal, they're certainly entitled to do that.
Any objections?
No objection, Madam Chair. I would note, if I may ask a question of Ms. Trinnell regarding Ms. Nooney's appearance. I think we established yesterday that Ms. Lael was the appropriate witness to talk about NOLs, and I just want to make sure, because I understand that Ms. Nooney is not available after 11 as she's driving to a family event. And we would prefer Ms. Lael to go first, but we recognize we only have 30 minutes until 11 a.m.
Right. I believe Crystal Lael was the witness that was identified yesterday that you wanted to speak with. Is that right, Ms. Trinnell?
Yes, I have very, very few questions
Okay.
on this. I hope that they'll give me somebody who answers them.
Okay,
Thank you.
so without objection, then we will take a short break, and then we will visit with Miss Lael when we come back from break, and then we will move into Montana 350 case. So let's take a 15-minute break. The time is 10:33, and we are now off the record. We are back on the record. The time is 10:49 a.m. And procedurally, where are we in terms of calling this witness? Okay, it's a little confusing because you rested your case, Ms. Turnell. You did reserve, and we did authorize you to reserve that. Would you like to just start your case in chief and present this witness? Or do you want to go back to cross and reopen?
I would like to call her and do just a couple of questions of cross on the May 11th emails.
We have no objection to that, Madam
Okay,
Chair.
without objection. Ms. Lael, are you available?
Good morning. I'm here if you can hear me.
Good morning. Okay, Counselor Turnell.
Thank you. Good morning,
And-
Ms. Lael. How are you? Can you hear me
Good.
okay?
I can hear you well. Yeah, I'm doing well. Thank you.
Great, thank you. I'd like to ask you about the May 11th emails that came in regarding the NOL updates and disclosures, which was an updated response to 350 Montana data request 100. Do you have those in front of you, Ms. Lael?
I do.
Okay, so in the original January response to that data request, in fact, these responses relate to information that was provided in response to MCC 84. Do you have that response to that data request in front of you as well?
I do not have MCC 84 in front of me at the moment.
Can you get it, please?
Sure.
Madam Chair, if I might, this is Ms. Norcott. I can email it to Ms. Lael if I'm given a minute.
Okay,
Wonderful.
anything we can do to expedite would be
The-
wonderful.
I can maybe make this simple through questions. She might not need the response.
Well, while it's being emailed, you can proceed with your question.
Thank you, Madam Chair. Ms. Lael, in this email, I see it as, I don't have page numbers, but the email is from Evan Verway.
Evan Verwy and Adam Spellman. Yes.
Great. And so Evan is writing on January 29th at 3 p.m. Do you see that email in front of you?
I do.
Okay. And Evan is identifying risk factors to disclose with the SEC. Do you see that?
Yes, I do.
Okay. And under the second star, under the risk factors, Evan says he talks about the NOL utilization. Do you see that?
I do.
Okay. And then what's the last sentence that he says there?
Are you starting with under the merger risk factor regarding NOL utilization? What was BKH federal NOL as of 12/31/25?
And what amount does Evan tell Adam? I think I've got these people right. What amount does Evan from your team tell Adam about what the NOL risk factor amount would be as of 12/31/2025?
Adam replies, yes, thanks for providing 380.1 million for Black Hills NOL at 12/31/2025.
Okay. And when you answered this data request in January, that NOL amount that was provided in that January response was about 548 100 million. Yes?
If that's what's in the data request, I'm comfortable with that.
Okay. And I recognize that this is a Black Hills, but you're the one that drew the short straw here this morning. So I'm going to ask you the questions. And then the update in April corrected that amount. Correct? Did it not?
I believe that's correct.
Okay. The differential being 155 100 million. Yes. Million. I'm sorry. I'm sorry. I said that wrong. $55 million.
Yes, I believe I'm tracking with what you're saying.
Thank you. The point here being that you knew the number in January, roughly what it was. You gave us a certain piece of information. You gave Wall Street a different piece of information, and you didn't tell us that that was different until May 11th, correct?
These documents were publicly available in February. We both filed our 10K then, and NOL disclosures are included in those every year. So that data has been publicly available since we both filed our 10Ks in February.
Right. The point being what you were telling your investors and filing publicly is different from what you were telling the commission and answering in data requests.
I disagree with that.
Thank you. I have no further questions.
Okay, thank you. Are there any further questions for this witness, Ms. Leo? Commissioner Molnar?
Thank you, Madam Chair. Good morning again, Ms. Lale.
Good morning.
Let me get up my Mr. Magoo here. I've got some scratches here. I had to go into YouTube to remember my questions for you. Okay, if there is a comfortable cushion of money in the northwestern part of Bright Energy Future, and then something happens, major forest fire and miles of transmission line go down, that would be probably BPA, but it serves everybody else, and distribution lines are melting as well. Would Northwestern have to borrow money to cover that because it uploaded some excess? Or is there a provision for Bright Energy Horizons to be able to put money back in or download it into one of their subsidiaries if they needed it?
So today we operate as a utility holding company. And today Northwestern Energy Group infuses funding down to Northwestern Corporation, the Montana utility, to fund regular operations. We are investing about 2 times depreciation. So on an annual basis, the amount of funds infused from Northwestern Energy Group down to Montana utility, Northwestern Corporation, to fund operations, the amount funded down is in excess of dividended up. The amount we can dividend up is protected by ring fencing and limited as to that. But yes, the utility holding company, Northwestern Energy Group, is a source of funding. In the future, Bright Horizons Group would be that same utility holding group that Northwestern Energy Group is. And based off the financial plan that we have, and it underpins this merger, we expect to continue to be investing materially in excess of depreciation. And I would expect that there would continue to need to be funding from Bright Horizons down to the Montana utility to achieve that. That's part of the efficiencies of capital at that level that will be helpful. And your point of, should there be an incremental need for funding, I do expect the holding company would be able to infuse that down and raise that efficiently if needed.
Thank you, Ms. Lale. Not too long ago, I read the quote ring fencing docket, which I looked at it more as returning to a normalcy and out of bankruptcy. The amount that can be uploaded isn't, tell me if I'm wrong, isn't really affected until there's a degradation in the credit rating. Until that point, there is no real limit. Is that correct?
It says that we have to maintain investment grade credit ratings. There is an additional piece if our credit ratings within that drop, but there is a more minimum standard of equity regardless that must be withheld at the Montana operating utility.
Okay. So under the proposed merger, where Bright Energy Future becomes the holding company, they don't exist yet, but that's my understanding of the plan. Will there be a percentage of profit per month or quarterly or whatever that would normally be transferred up to be a member of this? Or how will they determine how much money would regularly or irregularly be uploaded to the holding company from the subsidiary?
So the dividend upstream process that exists today and how we upstream dividends from Northwestern Corporation, the Montana utility, to Northwestern Energy Group today, and in the future, Bright Horizons Group will remain unchanged. The ring fencing remains unchanged. There are currently limitations on the amount of cash flows that can be upstreamed. Those will remain. So how that amount is determined will remain unchanged as an effect of the merger.
Can you tell me what the formulation is right now, the one that will remain unchanged?
So the ring fencing provides detail of that, but maybe to give you an estimation of that, Commissioner Molnar, last year we upstreamed, I think around 140 million of dividends, yet we funded capital of 430 million. So we infused capital down to the utility to be able to invest on our customers' behalf. We expect to continue to need to do that in the future based off our capital investment projections to serve customers.
Thank you. That brings a lot of clarity to me, and I appreciate your candor with it. And this will be my last one. Every time data centers is mentioned, we get an objection, and then we talk about them a lot. They seem to be pretty much central. I don't know about your operations, but in everybody's concerns. And it's a national phenomenon. Can you give me a region or a transmission organization or whatever in which the investments into data centers have lowered cost or lowered cost of capital because risk went down, that there was a benefit other than, well, they built a new transmission line, you didn't have to pay for it? I mean, a real benefit to the region.
Sure. Based off my knowledge in the industry, I can give you two close examples. MDU in North Dakota has explicitly stated that their customers are seeing a reduction in overall rates due to their service to data centers. Mid-American in Iowa has specifically said they've stayed out of rate case for over a decade, and it's because of growth in data centers, large loads. They're spreading their fixed costs over a larger set of loads. Those are two particular ones nearby that I would point you to. I think we all know that high capacity factor load, when appropriately regulated, can be very good for your other customers. But there's many states that have dealt with this. Obviously, others who have maybe had a different approach or a different fact pattern, but those are two I would point you to.
Okay, to narrow that down a bit, I would have to agree that Louisiana thinks they have a good formula. It's pretty new. I don't know if it's been tested. I think North Dakota thinks they have savings for ratepayers, and I think it's old enough to say that maybe they do. They also have very, very unique, individualized regulation, which I don't even know if we can do that. So let me bring it down just a bit for a broader concept. If the financing of data centers and the generation to support them is rate-based, are you aware of any really good successes as opposed to individualized regulation?
Yes, I believe in our separate docket, the large load tariff, we give quite a few examples of good, solid regulation that provides strong customer protections while also enabling the benefits on the system.
Thank you. Have a great day.
Thank you.
Thank you. So under this limited reopening with this witness, we had allowed 350 Montana to cross regarding the NOLs. And then Commissioner Molnar had also requested the ability to question Ms. Lael on these specifics. So I think we've gone through our cross for the second time and our commission questions for the second time. So without objection.
May I ask a question? I didn't ask permission ahead of time, but I had asked questions of Brian Bird about executive salaries, how they're determined, and he gave me some great general information, and he had recommended that I ask Ms. Lael for more details.
Go ahead, Commissioner.
Thank you. So Ms. Lael, good morning.
Good morning.
Can you explain to me generally how it is determined and what portion of executive salaries are recoverable in rates? How that's done and what portion?
So executive salaries, from a market perspective, executives have much more pay at risk. So there's your base salary that most people receive. There's your annual incentive, and there's a portion of that that's at risk. And then there is the long-term incentive that's tied to equity, which is also at risk. From a customer perspective, when we come in for rate reviews, we do not include executive long-term equity tied compensation. So I think Mr. Byrd acknowledged that part of that doesn't get recovered from that perspective.
So what does get recovered?
An allocation of your base salary and some portion of the variable compensation is included.
Thank you.
Okay. Seeing no further commission questions, I think we now go properly to recross based on the commission questions. Ms. Trinnell, do you have any? No recross? Okay. And then do we have any redirect from joint applicants?
Madam Chair, no redirect. Thank you.
Okay. Thank you for producing this witness again for us to have a second conversation with her. I appreciate that.
You're welcome. And Madam Chair, I would ask that one moment. Thank you. No further at this point.
Would you like this witness to be excused then?
Madam Chair, if we could have Ms. Little temporarily excused, just in case, depending on 350's case, we need to recall for live rebuttal.
Okay, Ms. Little, you are temporarily excused. Thank you for reappearing.
Thank you.
Okay, and now we will move to Montana 350's case in chief.
Thank you, Madam Chair. Montana 350 will call Tanya Bodell to the stand. And I believe Ms. Bodell was here when the witnesses were sworn in.
I believe she's been here all week long. Thank you for hanging in there with us, Ms. Bodell. Yes, I apologize for the lack of pedestrian flow in here. We're working on improving that.
Okay, thank you, Madam Chair. May I begin? Madam Chair, are you ready?
We are ready. Go ahead.
Okay, thank you. Thank you, Madam Chair. Okay, Ms. Bodell, you have in front of you 6 different sets of pre-filed testimony. We will go through those one by one and mark them and then move for their admission into the record. So we'll start with your pre-filed direct testimony, which was filed on February 9th of this year. We will mark that as 350 Montana Exhibit 1. Do you have a copy of that in front of you?
Thank you. I do.
Okay, and then and that has exhibits attached to it that are identified in the interior page there that are marked 350 Montana Exhibit 2 through 15. Do you see those exhibits?
I do.
Okay. And we are including those into the record with the pre-filed direct testimony marked February 9th. You also have in front of you what has been marked 350 Montana Exhibit 40, which is your pre-filed testimony regarding confidential information, the public version filed on February 13th. That's marked 350 Montana Exhibit 40. Do you have that in front of you?
I do.
And that public version has included with it 350 Montana Exhibits 27, 28, 29, and 30. Do you have those exhibits referenced there in front of you?
Yes, I do.
Okay, and then we have the third set of testimony that you have filed in this docket, which was the confidential version of the pre-filed testimony regarding confidential information submitted on March 13th. That is marked here today as 350 Montana Exhibit 41. Do you have that March 13th confidential version of your pre-filed testimony on confidential information with you?
I do.
Okay, and that has included with it exhibits the 27, 28, 29, and 30 that are also included in the public version of that same testimony. Do you have those references?
Yes, I do.
And then we have your fourth set of testimony, which is the pre-filed cross-intervenor testimony dated March 16th. And that will be marked as 350 Montana Exhibit 42. Do you have that in front of you?
Yes, I do.
And that has associated with it 350 Montana Exhibits 31, 32, 33, and 34. Do you have those referenced there with that pre-filed testimony in front of you?
Yes, I do.
And then we have your fifth set of pre-filed testimony in this docket, which is the March 25th public version of your pre-filed supplemental testimony regarding confidential information. And we will mark that as 350 Montana Exhibit 44. Do you have that March 25th public version of your pre-filed supplemental testimony on confidential information in front of you?
Yes, I do.
And then finally, your sixth set of testimony is the confidential version of that March 25th testimony, which we will mark as 350 Montana Exhibit 45. That is your pre-filed supplemental testimony regarding confidential information, the confidential version, 350 Montana Exhibit 45. Do you have that in front of you?
Yes, I do.
And that has attached Exhibit 350 Montana Exhibit 38. Do you have that reference in front of you?
Yes, I do.
With that, Madam Chair, we will move what has been identified. I'm sorry, I skipped a whole section. I apologize. Ms. Bodell, if I were to ask you the questions set out in these 6 different versions of the testimony that you have pre-filed in this docket here today under oath, would your answers to the questions posed in these 6 different sets of testimonies be the same except for any changes?
Yes.
Or do you have any changes?
Yes.
What are the changes? Let's start one by one with the Exhibit 350 Montana Exhibit 1, your February 9th pre-filed testimony. Do you have any changes to that?
I'm sorry, are these corrections?
These are corrections.
Then no, I do not have any corrections.
Do you have any corrections to any of the pre-filed testimonies?
No.
Okay. Do you have any updates to these pre-filed testimonies?
Yes.
What are they?
Sitting here today, it is my opinion that this merger causes harm to Montana
Objection that
customers.
this is improper direct testimony. The witness has had ample opportunity to provide testimony through the written testimony that's in front of us.
Ms. Trinnell, are we going to corrections of the pre-filed testimony to move admission of them?
Yes, I will move for the admission of these testimonies.
Okay, and can you please relist them for us?
Yes. Exhibit 1, 350 Montana Exhibit 1 is pre-filed direct testimony filed on February 9th.
And-
With the associated exhibits.
Excuse me, Ms. Shields, what?
Yes, I apologize for interrupting. I was going to say, we do have some objections to exhibits. However, we are willing to stipulate to testimony. And so I wanted to let everyone know that as far as the actual testimonial documents, we are willing to stipulate to the admission of those testimony. And then I am willing to walk through the list of objections that we have to the various
I
exhibits.
understand their subjection. So, go ahead, Ms. Trinnell. We have 350, Montana 351.
Yes, with the associated exhibits 2 through 15.
And what were those exhibits?
Exhibit 2 is Ms. Bodell's professional resume.
Okay.
Exhibit 3 is her bibliography of relied upon sources. And it's right inside her testimony, if that's helpful.
Okay. Is that, okay, there's more.
Exhibit 4 is a technical appendix. Exhibit 5 is 350 Montana excerpts of responses to data requests. And I did go through these to facilitate this today, and all of the responses that we relied upon in this testimony have been admitted into the record, except for 3.
Okay.
And so the 3 that have not been admitted into the record that were relied upon in this pre-filed direct testimony are 350-11, 350-87, and MFU 1. So those 3 responses to data requests are the only 3 that were specifically excluded by the commission that have otherwise been identified.
Okay, before we move to your next one, why don't we handle this one and make sure we're all good and straight on it? So are there any objections to Montana 351 with the exhibits? And do you need time to check that? We'll just take a minute and check. Make sure our records match yours. Any objections?
No objection to 350 Montana Exhibit 1.
Okay, without a, oh,
All the exhibits are separately numbered.
yes.
Sorry, I thought you were just asking about Exhibit 1. I can go through the list of 2 through, I forget what number it goes through.
Why don't we do this, Madam Chair, to facilitate? We are moving for the admission of Exhibit 1 and its associated exhibits 2 through 15, many of which have been already admitted. So if the applicants have specific objections, why don't we narrow this by identifying what they object to and then having the commission decide on those? Would that be helpful?
It could be.
Okay. So I don't know what the joint applicants are objecting to. We've moved for the admissions of 1 through 15.
Yes, and I agree that may be more efficient.
Okay.
We do not object to Exhibit 1. We do not object to Exhibit 2. We do not object to Exhibit 3. We do not object to Exhibit 4. We do object to Exhibit 5, only because the exhibit was never filed. To Ms. Trinnell's point, the discovery responses that have been moved into the record, we obviously do not object to, but we do object to 350-11, 87, and MFU 1, which have not been admitted into the record.
Can you go back, please, after you said 5?
5, we object to Exhibit 5.
And then what else?
I can go on to 6.
Okay.
6 Northwest's IRP, I believe that has already been admitted.
Yes, we took administrative notice of IRP 2026-0426.
Yes, we do not object to 6. We do not object to 7. We do not object to 8. We do object to 9. Those are letters of intent that were filed in docket 2022-09-078, in which the commission already issued an order denying admission of those by order 8043J.
Okay, so I think without objection, we can go through the exhibits that are admitted without objection are Montana 350, 1, 2, 3, 4, 6, 7, and 8.
So far, yes.
Okay. Where else are we?
So object to 9.
Okay.
No objection to 10. No objection to 11. No objection to 12. We do object to 13. And then no objection to 14 or 15.
Okay. So we will also admit Montana 350, Exhibit 10, 11, 12, 14, and 15.
And I'm prepared to move to the next testimonies if that's the appropriate order.
But yeah, I think we should
Sure.
dispense with this one.
Yes, ma'am.
This might be actually a little bit simpler than it appears at the outset, Madam Chair, if I may.
Go ahead. Ms.
So
Brown.
starting with 5, the first one that has an objection, there are 3 specific responses to data requests. We will withdraw asking for 350-87. So that leaves 2 for the commission to act on. That would be 350-11 and MFU 1. Our request to have these included in the record, although I understand the commission has excluded them, is that they relate to the joint applicant's responses address in MFU 1. The joint applicant's response states that they have no current or forecast electrical load obligations to data center customers in Montana. And we think that's relevant to the record in terms of what the merger docket does to that pending load and how that is handled on a going forward basis in the context of all of the issues that have been discussed throughout the last 3.5 days. And then with 350-11, that also addresses this is Ms. Jones and for Black Hills and Mr. LaFay for Northwestern answering a data request regarding interconnection, transmission, and operational studies. There was a lengthy objection, and then the response has to do with stating they don't expect the merger to impact allocation of costs. And we think that directly bears on their position with respect to impacts of the merger on cost allocation in this docket. And so we would ask that 350-11 and MFU 1 be included in the record as part of the responses to data requests.
Council Shields.
Yes, I mean, the commission has already received briefing on these and issued a decision specifically not admitting these due to relevance. The data requests specifically address large load interconnections, data centers, which are a matter pending in a separate docket before the commission. So the commission has already evaluated and decided this issue and not admitted these exhibits.
And all of, just for my edification, all of these are tied to Montana 350, number 5.
350 Montana, Exhibit 5 was an aggregate of responses that we relied upon. All of those responses to data requests are already in the record except for these two. So we are asking that that these two be admitted.
And Madam Chair, if I might raise one additional point of clarification, which was Exhibit 5, that amalgamation of data responses, that was never a document that was filed and served on parties.
Okay, thank you. Hold on just a moment.
We didn't provide an independent document because the data requests are in the record and it felt unnecessarily cumulative.
Thank you. That's what I understand now. Thank you.
And I'm not sure, we withdrew 87? Just, yeah.
That's correct.
So we're just asking for 11 and MFU.
You're looking at data response 350, 11, and MFU 1, correct? No. She withdrew 87. We're going to take another look at this, so just give us a moment or two. Why don't we go to recess for just 5 minutes? So the time is 11:27 and we're off the clock. We'll be back in just a few minutes. The commission will be back in order. All right. Thank you for the time to let us look through this and be thoughtful about our decision. And I appreciate the help of my counselor who spent a tremendous amount of hours going through these. With respect to Montana 350 Exhibit 5, which is, I understand it, is a request to admit data response 35011 and MFU 1, which have already not been admitted. The commission sustains the objection and will continue to not admit 35011 data response and MFU 1 data response. And 350 withdrew data response requests 87. So I think where we stand right now is Exhibit 5 is not admitted.
Thank you, Madam Chair. I would note that Ms. Trinnell and I had a moment to confer on outstanding objections and data requests. And I think we've been able to stipulate on a process going forward that we're happy to, or at least kind of where we've landed on what's at issue. If we might.
Yes, please.
That. We are willing to stipulate to the admission of everything except we have disputes over 9, 13, and 38. We can come back to those in a moment. For numbers 27 and 28, we both stipulate to administrative notice.
That was 27 and 28?
27 and 28, which I believe are references to the IRS code. So we would be seeking administrative notice of those provisions. We would similarly request that the commission take administrative notice of 34, which I believe is a referenced court decision. And so, again, we would come back, the three that we have differences of opinion on are numbers 9, 13, and 38.
Okay, so the commission will take administrative notice of Montana 350, 27, 28, and 34.
Thank you.
And then regarding number 9.
Yes, regarding both 9 and 13, the joint applicants object to those because they relate to number 9, letters of intent that were filed in a separate pending docket.
Right.
The commission already denied 350 Montana's request to compel the joint applicants to produce those documents in this docket through Order 8043J. Similarly, for 13, which is a letter from Northwestern dated March 4th to the commission, similarly in a separate docket, we object on relevance ground. Similarly, the commission has already denied 350 Montana's request to compel joint applicants to produce information related to LOIs with large customers, again. In
Ms. Shields, you are now speaking to 350 Montana 13?
Correct. 9 and 13, we object on similar grounds.
Okay. Okay, regarding Montana 350 Exhibit 9. The commission finds that 350 Montana 006 is relevant to this proceeding. No, that's 9.
Yeah, it should.
It's 33 Montana 350 009 is relevant to this proceeding and overrules the joint applicant's objection. So Exhibit 9, Montana 350 Exhibit 9 is admitted. Regarding 13, 350 Montana 13. It's okay. All right. The commission also finds that Exhibit 350 Montana 13 is relevant to this proceeding and overrules the joint applicant's objection. So Montana 350 Exhibit 13 is admitted. And now we will go to 38.
This was a publication, Madam Chair, from the MEIC regarding regulation of data centers and recommendations for Montana. It's publicly available. It is an online that our expert relied on in developing her testimony. So it would be admissible under Rule 702 and 703, the basis of opinion testimony by experts. The commission can certainly give to it whatever weight it thinks it deserves. So we would ask that it be included in the record and treated as the commission thinks appropriate, but it was relied on by Ms. Bodell in developing her expert testimony for Montana.
And we are speaking about 350 Montana 38, correct?
Correct.
Yes, and the joint applicants object to this on both relevance and hearsay grounds. The exhibit is being offered for the truth of the matter asserted therein, and we do not have the author of that document available for testimony. Ms. Bodell has put herself out as an expert, and she's available here for cross-examination. However, we can't authenticate that document.
Ms. Trinnell, do you have a response to that?
Rule 703 explicitly allows otherwise inadmissible evidence in that an expert has relied on. So under Rule 703, it would come in.
Okay, regarding 350 Montana 38, the commission finds that Exhibit 350 Montana 38 is hearsay and not admissible. And the commission sustains a joint applicant's objection.
Thank you, Madam Chair. So I think we are good here with those clarifications. 350 Montana will withdraw Exhibit 5 as a standalone exhibit. All of the referenced responses to data requests have been independently ruled on by the commission and are either in or out pursuant to the commission's rulings. So number 5 is withdrawn. And we have had the commission's rulings now on the other exhibits. And so with those rulings, we are moving for the admissions of Exhibit 1, the direct testimony and its exhibits as ruled upon. by the commission. Exhibit 40, the March 13th public version. Exhibit 41, the March 13th confidential version. Exhibit 42, the March 16th cross intervenor testimony. Exhibit 44, the public version of the March 25th testimony. And 350 Montana Exhibit 45, the confidential version of the supplemental March 25th testimony. With the exhibits as ruled upon by the commission, we move for the admission of these testimonies.
Are there any objections?
Subject to the decisions that have already been made, no.
Okay. All right. With the exceptions previously noted in the record, Exhibit 1, Exhibit 40, 41, 42, 44, and 45 from Montana 350 are admitted.
Thank you, Madam Chair, and we tender Ms. Bodell for cross-examination.
Thank you. Is there any cross?
Briefly, yes. Good morning, Ms. Bodell.
Good morning.
I'm Caitlin Shields. Thank you for being here.
Thank you.
Ms. Bodell, am I correct? You have been a consultant in the energy industry and energy regulatory industry specifically for nearly 30 years.
Yes,
Would you consider yourself a merger expert?
I've assessed mergers.
Okay. Routinely over the course of 30 years.
On and off, as mergers happen, they happen, and as bankruptcies happen, they happen. And yes, I have been involved with mergers.
Ms. Bodell, are you aware of Northwestern's pending large load tariff before the Montana Commission?
Yes, I am.
Okay. And are you aware of the commission's pending coal strip investigation?
Yes, I am.
Have you been retained for either of those proceedings?
No, I have not.
Okay. Ms. Bodell, in preparing your testimony for this proceeding, did you review the merger agreement? Did you review the merger agreement?
I reviewed the filing.
Okay. If we might be able to put in front, just for reference, it's Exhibit BBB1, which is part of Exhibit JA6, Attachment BBB1, and that is the merger agreement.
Okay.
Oh, and that's in front of you? Great. So this particular document here, did you spend time reviewing this in preparing your testimony?
Briefly.
Briefly, okay. Now, are you aware that the merger at issue here, that this is a stock for stock transition?
Yes, I am.
Okay. And are you aware that the merger agreement in front of you does not contemplate an asset purchase, any asset purchases or any asset purchase and sale agreements?
Yes, I am aware of that.
Okay. Are you aware that there is no acquisition premium that Northwestern customers or Montana customers are being asked to pay associated with this merger?
I reviewed what was reported to the SEC with respect to the back and forth about the negotiations, and I understand that there was discussion about a premium, and at this point, there was a price that was settled upon.
Okay, but you understand, pursuant to the settlement agreement that Black Hills Northwestern, the joint applicants have entered into with the MCC and with the large customer group, that they have committed they will not seek to recover an acquisition premium from any Montana customers, correct?
And by acquisition premium, you mean a price on top of what the market traded price of the stock is?
Right. And specifically, I believe the term used in the settlement is goodwill.
Yes.
Okay. Now, would you agree that the commission's regulatory authority and jurisdiction over Northwestern's Montana utility will not change post-merger?
I agree that the commission's oversight of the Northwestern utility will not change, but I also recognize that with a different organizational structure, there are things that may be outside of the commission's control that were not outside of their overall approach before.
Okay. And one thing, this is a bit of point of clarification, but you are familiar with Northwestern today has a holding company, correct?
Yes, I am.
Okay, and that would be the Northwestern Energy Group holding company, correct?
Could I reference that slide for the name?
Yes. Sorry. No problem.
Multiple uses. Yes.
Okay. And the commission does not have regulatory authority over Northwestern Group, correct?
That is my understanding, the same way they would not have control over Bright Horizons.
Okay. And you're also aware that Northwestern Group has operating utility companies today in Nebraska and South Dakota, correct?
Yes.
Okay. And it's your understanding this commission today does not have regulatory jurisdiction over the Nebraska and South Dakota operating companies, correct?
Yes, Montana's Public Service Commission does not have control over the utilities that are in other jurisdictions.
Now, you are familiar, Northwestern Energy Group does have a holding company, utility operating company, rather, here in Montana, correct?
Could you clarify that question?
Yes. So another entity we've heard the name of, Northwestern Corporation, doing business as Northwestern Energy, is the regulated utility company here in Montana, correct?
If I could just check the name.
Absolutely.
Yes.
Okay. And this commission does have regulatory authority today over Northwestern Corporation, doing business as Northwestern Energy, correct?
That is my understanding.
Okay. And that authority includes rate-making authority, correct?
Yes.
Rate design, cost allocation, correct?
Specifically for that utility, yes.
Okay. Resource planning. So we've been talking about the IRP, integrated resource planning.
Yes.
Okay. And that would also include authority over customer classes such as new large loads as set forth in the proposed tariff, correct?
For purposes of Montana, I'm assuming your questions are pertaining only to Montana and that utility. Yes.
Okay. Thank you. I have no further questions for this witness.
Okay. Are there commission questions for this witness? Commissioner Pinocci?
Thank you, Madam Chair. In your opinion, you don't believe this merger should go forward, and tell me why.
So thank you for the question. Having sat in here, looked through all the evidence and assessed this, it's very clear to me, based on what's in the docket, there's no economic benefit. There's negative net benefits. There is harm to customers, and it's not in the public interest.
We heard testimony earlier from Ralph Smith, Montana Consumer Council, where he had concerns, didn't believe the merger should go forward, and those concerns were addressed, and now he feels comfortable with it. Did they make any attempt to give you good answers to your concerns?
So initially, there was a dearth of information to do an assessment of what the impact would be. Since we've arrived at this point, the numbers are very clear in my mind that there is definitely harm to the Montana captive customers. And the math is simple, and I can even show it to you, as well as for the broader merger itself, that there are negative net benefits.
I think we're going to get to you to show us the map, but I've got a couple of questions that you may address when you're doing the math. So let's go down this road. You brought up concerns that Black Hills is not meeting green energy goals as well as Northwestern. And I got to tell you, Montana, and I want to see if you agree, has really cut carbon tremendously. We shut down half a coal strip. We shut down the coal plant in Sydney. We've increased wind substantially. So when I'm at these events outside of Montana, I can show Montana as a leader in cutting carbon and moving towards green energy. Okay. Is it possible that Black Hills joining in this merger might encourage them to go down more green energy? Is that a possibility?
Yes and no. So I think that each utility, including Black Hills, has their own environmental goals, and they're going towards those goals. In addition, They're utilities that are regulated, have state obligations, and they're moving forward with that. From an economic perspective, Black Hills is a very large, I mean, when I say very large, compared to Northwestern, they have a larger portion of natural gas pipelines. So I would anticipate, as part of the merger and the connection of new load and new resources, that economically they will be incentivized to build out natural gas plants versus a renewable option, subject to the constraints placed on them by their state and their regulators.
The new modular nuclear reactors.
Yes.
Very clean. And now we can recycle the pellets. And we understand that there's a plant that will be brought online in Wyoming. Would that increase the green energy level if that comes online in Wyoming? And wouldn't that really be the future more so than coal or, say, a gas plant? And I guess another point I want to make is this: do you believe that Montana will increase in the future carbon, or do you think that we're really going to take a serious look at the modular reactor, which is zero carbon, and that is being produced, and they're building that in Wyoming? Tell me about that.
And you're asking with respect to this merger or in general?
Well, I guess I didn't ask this question. If this comes online, this new modular reactor in Wyoming, will these two entities get the power?
My understanding is that the modular nuclear technology is still early. We don't have a lot of experience in how they operate. I have hopes, as we've heard, but I have hopes that this is a solution to carbon. One of the things the modular nuclear reactors are very good for and may proliferate with are, I apologize, data centers, because they have a matching load profile. So the nuclear reactors tend to be 24/7 round the clock operation. And similarly, the data centers are 24/7 round the clock operation. So it may be that there is modular nuclear reactors that become economic and are determined to be safe, may proliferate in the future. Right now, we have very little experience with the modular nuclear reactors, and I'm not in a position to opine on whether they're definitely going to be going forward. But it is definitely a resource option that is increasingly available to utilities that need to serve load.
Well, I guess what I'm getting at is your testimony has got concerns that carbon will increase, but our neighbor in Idaho soon is going to turn on their modular reactor. I understand the testing is done. So I think the future of cleaner energy is maybe a better point, or at least should be addressed as a possibility. All right, so you say other states address data centers and the risk they pose in existing electric customers. And tell us a little bit about your testimony. I got page 34 and line 8, where you say, yes, many other states have required data centers. Go ahead.
And I will ask that the conversation here be focused on with respect to the merger and how the merger would affect.
Well, I'm just in your testimony.
I know, but the record's been, we've been limiting the record to ensure that we're talking about the merger itself and the impacts of the merger. So I'm just going to remind commissioners and witnesses that that's what we are interested in. We're interested in knowing whether this merger is something the commission should approve or not. And we've reserved a lot of the exhibits that had been attempted to be moved on that go into the details of data center and data center loading that are specific, more specific to the actual large load tariff docket. Those are going to be addressed there. So I'm just a reminder, we want to talk about the merger.
So I will try to aim my comments on that.
Thank you.
I will also say that my answers to the PSC inquiries around this language has a lot of material that could be very useful as they contemplate the large load tariff, because it goes into additional detail on what other states have been doing and why. But with respect to the merger, at the time I wrote this expert report, you may recall the large load tariff had not been filed in Montana. That anytime there's uncertainty, when there's not a final large load tariff, when there's not a final IRP, when there's not a joint IRP, that type of uncertainty creates risk. It creates risk for the utility that's being acquired or merging. It creates risk for the Montana customers. And what I was highlighting here was the risk that was being imposed on Montana customers with the timing of this merger and the timing of the large load tariff. The large load tariff, I understand, is still not finalized. Perhaps it could be withdrawn. Maybe after the merger, it could be replaced with what is being used in North Dakota and the other areas. I believe it's North Dakota where Black Hills has a large load tariff. There is still uncertainty, and that uncertainty imposes risk because this is a huge, I think every utility expert, every utility fact witness and expert has said, this is a huge change for the industry. The amount of load coming online in the short period of time, these data centers want to get quickly onto the system. Quickly, they now consume 6% of the electricity produced in the United States and are projected to consume 17 to 20%, according to the Department of Energy, going forward. This is a huge change. The regulatory system is not set up to deal with that. And that's what a lot of my testimony referencing what other states have done talks about. And I put that into this testimony to give the commission an opportunity to consider. At the time, there was no large load tariff, but you can still consider it today. Do you want to impose as a condition of merger that there be a large load tariff in place? And now that you have an initial filing of a large load tariff, do you want to impose the minimum conditions they've already said they're willing to comply with, subject to potentially changing your mind afterwards? You as a commission can do that, I believe, in your order. So that was the basis of this. I don't know if that answers your question, but I definitely tried to keep it tied to the merger.
Thank you.
Right. One of the reasons the question is because there's such a concern from the public reaching out to me in emails and phone calls. And I really respect the merger explaining that it does not have to do with data centers. And I'm trying to explain that at the same time, trying to address the concerns. People are scared. They're uncertain what this is going to mean as data centers come forward. But I clearly understand that it may not be part of the merger. Let's talk about page 18, line 13. Even if the increase in earnings per share is achieved.
So sorry. Could you just give me the page again?
Page 18.
Of my
Hearing binder 947 in red, and I have page 18.
Sorry, is that my, I'm sorry, pre-filed direct testimony?
Direct.
Okay.
It is called pre-filed direct testimony.
Fabulous.
Okay. Should have said that in the beginning. So I think that your question that I'm trying to achieve here is, if they get higher earnings and a higher stock, tell me about your response to this.
So on page 18, there's been discussion about a lot of earnings also can flow back into Northwestern. It may or may not. And there's no guarantee that it would. An increase in earnings generally goes to three places. Taxes, it goes to shareholders, and it goes back into the companies, investment back into the companies. And given the larger organization, there's no guarantee that higher earnings for the corporate entity Bright Horizons will be invested at the same level back into Northwestern as it would have been without the merger.
As a commissioner, when a company, utility says we need to raise rates, if I'm able to point at you're making record profits, could say you need to lower your rates. So why, if I saw greater earnings and a higher stock, why wouldn't the commission kind of respond that way if they're asking for a rate increase?
Because the commission, as we heard from the MCC expert, and as you know as commissioners, there's tracking for purposes of rate making, and there's rates and cost of service rate making that are followed. And so the rates that you would set for an individual utility is more going to at least start with what's the rate base, what are their expenses, what does this utility need to recover under cost of service rate making. If it turns out a bunch of, for example, competitive entities at Bright Horizons are making tons of money because they're providing the generation to data centers, there's no requirement that Bright Horizon sends money back down to the utility as part of a lower rate. There's no basis for that. You can ask for it, but you only oversee your utility, Northwestern, in Montana. What happens in the rest of the entity does not necessarily give you anything other than an ability to request under cost of service rate making.
My ratepayer is concerned, you might have heard from earlier testimony, that in this merger, Black Hills is getting a better deal merging than, say, Northwestern is with Black Hills. Do you have an opinion on that? And this kind of supports where money might go, maybe to another state. Tell me about that. And did you address that, or did you have a concern with that?
So I did not assess who's getting the better deal on the stock for stock transaction. What I did focus on is what's the impact on Northwestern's captive customers. I also looked more generally at whether or not, based on what's in this docket, there are net benefits, and I've come to the conclusion that they're negative. And I've also, as part of that, in trying to understand why are they doing this, looked at some of the potential explanations, and in my opinion, that would not be in the public interest of Montana. But I have not looked at who's getting the better deal.
And I certainly don't know. It's just the ratepayer is asking me to bring that out. Let's go to page 6.
I will say this. I don't think the ratepayers are getting a good deal at all.
Okay.
I think they are harmed by this merger.
And we'll get to the math. Let's go to page 6, line 13. While you're getting there, what are the major risks that Northwestern and its existing Montana ratepayers face if the merger were to proceed as proposed?
So thank you. And again, this was in February. I continue to stand by this. I divided the risks at that time, and I continue to believe these are natural buckets, into financial stress associated with the anticipated expansion levels following the mergers to connect the data centers in different service territories, despite the larger balance sheet touted as a key benefit of the merger. Again, I'll go to the fact that combined, they have 4,500 megawatts of potential additions, and that is more than a doubling of the system. In the case of Black Hills, it's a tripling of the size of their peak system, their regulated system. There's inappropriate tariff increases on Montana customers that could result for a variety of reasons that I indicated. One, you can't just ask a holding company to give you a break and do lower. You can ask, but they're not under any obligation to agree to lower rates just because they made a ton of money off of a competitive generation entity or their other utilities. So there's potentially inappropriate tariff increases on existing Montana customers, in part because you've done such a good job of keeping the regulated rate of return lower than what Black Hills has been able to get from their regulators. I would anticipate they'd want to raise the rate of return. In addition, there's potentially hundreds of millions of dollars of transition costs associated with this merger. We don't have an actual number in the record. In the confidential docket, we've gotten some indicators, and a share of that is going to most likely be placed onto Northwestern. And those would be the reasons why I would anticipate there's going to be upward stress on the tariffs. And we haven't heard anybody say there might be lower rates as a result of this. It's only that they might be lower than they otherwise would be.
I've certainly brought that question up again and again. I think this is my last question. Go ahead and show us the math. And after that, Madam Chair, I will have no more questions.
Monica, can I just want to use the back. Sure.
Can you give her maybe one of the portable mics so she can talk while she's drawing? If needed. Or maybe assist her, Ms. Trinnell.
And Madam Chair, we would like to lodge our objection, and I appreciate Commissioner Panochi wants to give the witness an opportunity to offer some new math, but this is clearly new direct testimony. This is outside the commission's practice and the procedural rules governing this proceeding.
Okay, so the objection is sustained, but what the witness, Ms. Bodell, you're free to highlight the testimony, the math from your testimony. That's fine, but new testimony, new math today would be outside our scope.
Okay.
And Madam Chairman, I think that's a good point. And I meant for you to show math based on your testimony. I could have made that clear when I asked the question. I did not. Yeah.
And may I respond? I don't think this isn't new information. It's synthesizing what's already in the record for clarity for the commission. So it can understand the information in front of it. That's the point of us offering an expert.
Okay, that's where I was going. If you're highlighting and summarizing what's in there for us, that's fine. Did you have something, Mr. Green?
Madam Chair, council just put a new document in front of the witness, and we were just wondering what that is.
Okay.
Okay.
Ms. Bodell.
And just to understand, because some information was put into the record after I filed my testimony. Okay. Am I able to talk about that or not? For example, this morning there was discussion on the NOLs. We received information about the fact there weren't models on the NOLs that was provided on Monday night. I don't know if just please give me guidance because I can also stick to what's in
Madam Chair, as a matter of law and argument here, our request for the commission is to allow latitude for our witness to address the late filed information that has come in, the NOLs, all of the information. It's in the record. It's before the commission. It's been developed. Ms. Bodell is simply making sense of it from our perspective. And we think that the commission should inquire of this and have it developed from our perspective. And so.
Okay, I hear you. Mr. Green.
If she wants to talk about the NOL emails that were produced, I guess that's fine, but the NOL information was in the record.
Now, I'm going to actually, I'm going to object to that. I think that it's not just an email. There were significant draft documents from January, many, many pages that we saw for the first time on May 11th, talking about their drafts of how they were analyzing the risks of the merger and the impacts. Ultimately, information was put into the SEC, as we heard from Ms. Lael, but that's different from what their draft information was, and what was filed with the SEC is different from what they told us in the underlying data responses that they then corrected on April 30th, supplemented on May 11th, which tells us that they knew in January what this information was. We are live time trying to respond to various information from a multi-billion-dollar corporation we're just trying to give the the commission a little bit of information. At a minimum, take the information. You might not use it. You might not like it. You might give it a little bit of weight or none at all, but just take the information. That's what we're asking.
Thank you, Ms. Trudeau. Mr. Green?
Madam Chair, there are rules of procedure, there is due process, and I'm not, I mean, the 10K drafting process is a lengthy process, and certainly there are drafts of those that are exchanged. We tried to provide information relative to the NOLs. You've also heard from our witness, and you've heard from the MCC's witness, that the NOLs are not an issue here. So if Ms. Turnell can lay the foundation that this witness has any accounting expertise and understands NOLs at all and wants to talk about that, she certainly has testimony about NOLs in her direct testimony. And she can, the commission can inquire about those, but coming up with new information this late in the hearing is inappropriate.
Thank you, Ms. Bodell. Mr. Green, the information that was provided on May 11th was very late. And so to the extent that the witness would like to address what's in that information that was provided on May 11th that would have changed her testimony without that information, I think that's fair.
Madam Chair, that would certainly be an appropriate question relative to those exhibits. That's not the question that was pending.
Okay. Ms. Turnell, can we, do you have any objection to proceeding along those lines with the discussion of the NOLs?
I think we're.
Okay. Commissioner Pinocci, I think, wanted some math, and I see that you drew up some math up here. And again, if the objection, there's a few objections here, but where we're at is that if you can, if there's any new testimony that you have, to the extent that it relates to the new information in the NOL, I will permit that. But otherwise, if you can just summarize your testimony and the mathematics, any mathematics that you provided in your testimony, highlight that for us.
So everything that I'm going to put into this side by side is in my testimony.
Okay.
Except for the $10 million settlement, which wasn't done at the time.
And can you keep it brief so that, because we do have your written testimony?
Yes.
Okay, thank you.
Okay. So I'll quickly write down the entries and then talk through them.
Madam Chair, this is unnecessarily cumulative. Her pre-filed testimony is in the record.
Noted.
Excuse me, Madam Chair. Ms. Bodell, would you have a darker colored marker you can use? Those are washing out from this range. You know, black or something looks like that's a.
I actually think it'd be helpful, Ms. Bodell, if you just talked us through it so that the record can pick up what you're trying to communicate to us.
I will. Okay. So at this point, based on my testimony plus the $10 million settlement, it is my conclusion that there is harm to Montana customers, and here's why. You start with $10 million. That's the only valid number with respect to the benefits to the Montana customers that's in the record. The net operating losses are an offset to that. These are $800 million of net operating losses, and I've talked about this in my confidential filings. I don't want to say extensively because I tried to be brief, but these have value, and these with the new merger are able to flow up into the corporate entity, and I don't think this is inconsistent with what the utilities experts have said. And once that gets monetized, turns into cash. The Bright Horizons has a decision about where that cash goes. Some can go out to the investors as dividends. Some can go into other parts of their business. There's no guarantee that the cash value of those NOLs comes back down into Northwestern. This is in my testimony. What does come down is the accounting and the rate making tracking, but it's not the same. Cash is cash. What's book value is book value. That's a big negative. It's hundreds of millions of dollars potentially that may go out the door. Higher rates, because of the transition costs we talked about, pressure upward on rates. Higher ROE, for the reasons in my testimony about the higher return on equity, pressures. Debt, maybe, maybe not. In the SEC filings, under the merger risks, it says debt costs might be higher as a result of the merger, and that's in the record. So higher rates pressured up to the negative of the Montana customers. Lower capital. My testimony also talks about the incentives, about how, I'm sorry.
So Madam Chair, this was
okay.
not Commissioner Panocci's question.
Well, Mr. Green, I appreciate that, but Commissioner Panocci asked for math, and to the extent that you can give us the math, and I think you did in your top 2 points there. So if you could wrap up and stick to his question.
So that lower capital has potential decrease in the reliability, as we talked about. That has a cost. Hard to believe that the reliability can go up because this utility has very high reliability numbers. And then whether or not the capital comes down to the Northwestern with respect to new capital is a decision of Bright Horizons. And those new connections that you can express concern about, Mr. Panocci, may not happen because the capital isn't there.
All right, thank you. Are there any other commissioner questions for this witness? Commissioner Bukacek.
Thank you, Madam Chair. Referring to your answers to another commissioner's questions, there are complex reasons why increase in profits and earnings of a holding company do not directly bring a decreased rate for customers. Would you agree?
I agree.
And is it true that the current holding company, Northwestern Energy Group, that would be true of them as it would be for Bright Horizons should the merger pass?
I do, with one exception, which is under the merger as proposed, there are 2 levels above the Montana utility, Northwestern. And those 2 levels means that there's 2 decision makers, and one is above Northwestern Corporation, which adds to the complexity and the pressure to provide dividends to shareholders and to invest back into the other businesses of Bright Horizons. Increases the complexity, increases the risk to Montana customers.
Okay. Thank you.
Any other commissioner questions? I want to follow up on that. So on the 2 layers that would be above the regulated utility, is it your understanding that the Northwest Energy Group would still be above Northwestern Energy, the utility? Or would Northwestern Energy Group be merged with Black Hills and become the one consolidated parent company?
So my understanding is based on the organization charts that were provided under the interrogatories and then combined. Under the post-merger legal organization, and in that depiction, as you know, there's not a combination. So the 2 levels of corporate organizations that I was talking about under this organization chart would be maintained.
Okay, thank you. All right, council, do you have any questions? All right, we are on recross then. Is there any recross for this witness based on the commission questions?
Yes.
Ms. Shields?
Madam Chair, with the new information on the NOLs, would it and given the hour of the day, would it be appropriate for us to break for lunch so we can confer with our financial witnesses? And we'll take a picture of this document and confer over the lunch hour on those issues and come back.
Yeah,
Madam Chair, I'd also
that's fair.
request that a copy of Ms. Waddell's notes be made available for the record and so that we can review those as well.
Okay, we can get a copy of those. Our secretary can make a copy of those for you if you're all right with that.
Yeah, I'm
Okay.
sorry, just to be made available to us.
Oh, okay, that's fine.
Yes, and to be clear, we would request all notes that she's been relying on.
This one's the only one I've been relying on for the chart that I did.
Okay.
To the extent she has other notes up there, I believe that we're entitled to those.
I believe that's true. So if you can make those available, we'll get a copy of those and we'll do that during the break. So we'll take a 1 hour lunch break, well, hour and 6 minutes. So time is 12:24 and we will come back on the record at 1:30. We are now off the record. The time is 1:32 p.m. and we are back on the record. And we had finished commission questions and we are now back to recross. So, joint applicants.
Yes, briefly. Ms. Bodell, you were asked a couple of questions. I think the question from Commissioner Pinocci began with why this merger should or should not go forward. One of the things that you raised was net benefits. And your claim there are no net benefits. And specifically, one of the things that has come up is the concept of savings. And I think a $70 million figure is what we've generally been talking about. Do you recall that in projected savings? When you talk about $70 million, is it your position that that is a figure that would be a one-time accrual, or that there would be ongoing savings that would be driven by the merger?
So that is the number that's in the record.
Okay.
That the parties have discussed. And there's been no indication it's ongoing.
Okay.
It appears it was one-time savings on a net present value basis, but the underlying calculations have not been provided.
Okay.
And it's unclear. But at no time did the witnesses ever say it was going to be an annualized number.
Okay, so taking it back a step further from that $70 million figure, to the extent that there are savings, you would agree, I think that Commissioner Pinocci had spoken earlier today, perhaps with a separate witness, but gave some examples of potential areas of savings. For instance, executive compensation. Is that an area where you would agree there will be savings?
My understanding of the $70 million, well, 48 to 70 million, because there's a range.
Mm-hmm.
My understanding is that that was the estimate of potential value creation or synergies associated with the proposed merger.
Okay, understood. And to be clear, I'm asking conceptually about savings. I'm not asking about the number at the moment. Would you agree that there will be some savings? And I'm not asking if those savings will be outweighed by other costs, but there will be some savings, for instance, in the form of executive compensation, because there will be fewer executives to pay.
So that analysis was never provided, and I cannot get into details because of the confidentiality agreements, but there were numbers that broke out what portion of the savings would be due to employment changes. And I believe there may be a number in the public record that indicates a value for that.
Sure, and I'm not asking about the numbers. I'm just asking in concept. Would you agree that there will be some things, perhaps like fewer executives to pay, that will result in in savings from the merger?
I would agree with that, and I would also say that the number put into the record by the joint applicants includes those types of savings that you're describing.
That's your position, your understanding, right?
That's my understanding based on the answer to the interrogatory associated with questions about value creation or savings. And I believe there was a number broken out in the public record that indicated that was associated with lower costs tied to employees.
Okay. Earlier, I think Commissioner Pinocci had given an example of perhaps billing system changes, and by consolidating billing systems, for instance, or perhaps a building isn't needed because the companies can use one building for billing systems and billing people and billing operations, that could result in savings. Do you recall that exchange?
I do recall that exchange, and I recall a lot of discussions about the types of savings that this proposed merger could create. And the only numbers in the record that try to quantify what those savings are is the $48 to $70 million. And in addition, there's an undefined number for the transition costs, which could be significant, and way outweigh any of this. In addition,
Ms. Bodell, I'm not asking you about the numbers. You've had your chance to be cross-examined and submit testimony. I am not asking you about what the numbers are and what's in the record.
I would ask that the witness be allowed to answer. That's been the admonition all along for us.
Thanks. Objection is noted, although as I have admonished other witnesses, we want to hear answers. We don't want counsel cutting off some witness at midstream, but the witness does need to answer the question briefly and concisely without elaborating on other narratives. So just let's just try to do that, and we'll be able to move along and get what we need.
Thank you.
So my next question, to the extent that there are savings, for example, through billing system consolidation, supply chain economies of scale, or executive compensation, would you agree that those savings will be ongoing and not one time?
Are you talking about net savings or gross savings?
I am talking about gross savings right now.
Yes, gross savings could be ongoing. They could be one time. And in addition, there's usually costs that are associated with those gross savings.
Understood. Thank you. One other question. I believe you made a comment. We were talking about the large load tariff. You indicated, I think this may have been again during your exchange with Commissioner Pinocci. You stated that the current pending large load tariff could be withdrawn and replaced with the tariff serving North Dakota. Do you recall that comment?
I do.
Okay. In that hypothetical scenario, wouldn't you agree that if the large load tariff were withdrawn, for any sort of new or other large load tariff to replace what has been proposed, that would have to be filed with the commission and go through a regulatory proceeding?
Yes, I do agree. And the commission absolutely has the authority over the large load tariff. But with this proposed merger, you also have the ability to place conditions on the proposed merger that may be very helpful to set a minimum starting point for these types of major issues that continue to be uncertain. But yes, I agree that the commission would have authority over a large load tariff for the Montana utilities.
Okay. Ms. Bodell, prior to the lunch break, you were asked to produce notes that you relied on at the witness stand. Is that right?
That is correct.
Okay. And you've been under oath and on camera here at the commission, right?
Yes.
Okay. You produced 3 pages of notes, correct?
Yes, I did.
And was that a full and complete set of the notes that you had at the stand with you prior to lunch?
No.
Would you please produce the rest of the notes? Thank you. And Madam Chair, might I ask to who we might tender these notes for copies?
Yes, council will take care of that. If council, you could make a few copies across the hall.
Okay, if we might have a brief moment, I'm not sure I have any further questions, but if we might have the opportunity to review those briefly.
Okay, so there was one additional page of notes.
Yes.
Okay, thank you for producing that. And we will just stand at ease for a moment. We'll go ahead and go off the record. The time is 1:40 and we'll resume shortly. Don't go anywhere.
We are prepared to go back on.
The time is 1:42 and we are back on the record. And I would just note too, that the three pages of notes from this witness, Ms. Bodell, that were provided before the lunch break were copied and given to Joint Applicants Council and to Montana 350s Council. And then the original 3 pages were returned to Ms. Bodell. And now one more page has been produced and copies have been provided to the Joint Applicants Council and to Montana 350s Council, and the witness has her original copy back, right?
Yes.
Okay, thank you. Ms. Shields.
Yes, thank you. And Ms. Bodell, I'd like to thank you very much. I have no further questions for you.
Thank you very much.
Okay, so we are back to then redirect. Ms. Trinnell, would you
Thank
like to
you,
redirect your
Madam-
witness?
Thank you, Madam Chair. I don't have any questions. I want to move for the admission of the 4 pages of notes as 350 Montana Exhibit 66 into the evidentiary record.
Objection, Madam Chair. Those notes were used by the witness for her own prep, and we just asked for them to review their inappropriate evidence for purposes of the record of this case.
At this point, I would, they asked for it, they can't have it both ways, and at this point, any reviewing body would need to have this in order to assess what has happened here today. I'm also going to ask for a photo of the math that was done to be moved into the record as 350 Montana Exhibit 67.
Madam Chair, same objection. That's irrelevant. It was improper testimony at the time, and it's an unfair characterization to suggest that that is math.
They can characterize the exhibit any way they want in their briefing. We're asking that the evidentiary record reflect what the commission has considered before it during the proceeding.
Okay, Ms. Trinnell, what were the numbers you assigned to those?
The notes exhibit 350 Montana Exhibit 66.
56?
66.
66, okay.
And the math chart, 350 Montana Exhibit 67.
Okay, so the math on the display board was demonstrative and that was fine for guiding the discussion. The notes were the witness's notes. It's not that she testified specifically to these, so the objection is sustained and these Montana 350, 66 and 67 are not admitted.
Then I would ask to have an offer of proof under Rule 103 and have them included in the evidentiary record as an excluded exhibit of the notes as discussed.
Noted.
Thank you.
All right, redirect, Ms. Trinnell?
No redirect. Thank you, Madam Chair.
Okay, thank you. Would you like your witness to be?
I would ask that the witness be excused pending recall, depending on what the joint applicants do with Ms. Lael at this point. But we'll be here for I think, the next hour of the hearing, and I think hopefully we'll be done by then. But I want the option to recall her if I need to. I don't know what the joint applicants are going to do at this point. They haven't told me.
Okay, Ms. Bodell, you are temporarily excused.
Thank you.
Thank you very much.
Ms. Trinnell, do you have another witness?
We do. Thank you, Madam Chair. 350 Montana calls Tom Schneider to the stand. And I do believe Mr. Schneider was here when the witnesses were sworn in.
Mr. Schneider, were you sworn in?
Yes, I was.
Thank you.
Thank you, Madam Chair. Good afternoon, Mr. Schneider. Have you been here through this whole hearing?
Have, except for the confidentiality sessions.
Okay. You have in front of you what has been marked as 350 Montana Exhibit 19, which is the amended pre-filed direct testimony filed on February 10th, 2026. And I'm sorry, that's exhibit 3. Did I say 350 Montana 19? That's okay. And then 350 Montana Exhibit 20, which is your professional resume, which is attached to that. Do you have that in front of you?
Yes.
Okay. Then you also have in front of you what has been marked 350 Montana Exhibit 43, which is your pre-filed cross-intervenor testimony submitted on March 16th, along with a timeline that was included with your testimony and marked at pages 19, 20, and 21 of your testimony marked as 350 Montana Exhibit 21. Do you have that in front of you?
I do.
Okay. Have you had a chance to review your pre-filed direct and your cross-intervenor testimonies?
Yes.
If I were to ask you the same questions that are posed in those testimonies here today under oath, would your answers be the same except for any changes?
Yes.
Do you have any changes?
There is one clarifying edit that involves insertion of an E and the entry of a space.
Okay, can you direct us to the specific page and line where that should be corrected?
It's in the pre-filed cross intervenor testimony at page 8.
Okay, and page 8 and what line?
It's lines 22 and 23 to focus you.
Okay, and the last sentence on that page, what is the specific correction that you are asking?
It should read the remaining rate base is over $255 million.
Okay. Do you have any other changes or edits to your testimony?
I do not.
Have there been any significant developments since you filed your testimony?
Objection. This is outside the scope of typical direct for the commission.
Mr. Now?
Yeah, the request is to acknowledge the significant developments of the large load tariff and the IRP.
Madam Chair, this commission requires pre-filed direct testimony. It doesn't allow for an update at the hearing to that direct testimony. It allows for corrections to that testimony. I think it's unfair to the process to now add to that testimony.
So we will move on. I'll move for the admissions. I'll withdraw the question, Madam Chair, and move for the admission of exhibits, what has been marked as exhibit 19, 20, and then the cross-intervenor testimony is 43 with the embedded exhibit and timeline of 21.
Are there any objections?
Madam Chair, joint applicants do not object to the admission of 350 Exhibit 19 with the embedded exhibit. Joint applicants do object to the exhibits that are attached to 350 Montana Exhibit 43, and I'm happy to address the objections to those two exhibits labeled Exhibit 21 and 22.
Okay, so 350-19 is admitted with the embedded exhibits. And I'll hear argument on the objection.
Thank you, Madam Chair. First, I will begin with Montana 350 Montana Exhibit 21, which appears to be a timeline. The joint applicants object to the omission of this document on the grounds of relevance foundation. It's misleading under the rules, Montana Rule of Evidence 403. It's also in violation of Rule 1006 regarding improper summary of testimony. That rule allows for summaries in certain circumstances. This is not permissible. It's not a permissible summary in this case under that rule. More importantly, though, the joint applicant, or Ms. Trinnell 350, has failed to establish foundation for this exhibit and who created this timeline. Additionally, it causes confusion as it selectively emphasizes certain data incompletely. And so we would object. Additionally, we think it's irrelevant for grounds we've already mentioned about Colstrip.
Ms. Trinnell?
If the commission looks at Mr. Schneider's pre-filed intervener testimony at page 10, Mr. Schneider lays out in his testimony the timeline of events that he testifies directly about, and sets out in there the unfolding of events surrounding Colstrip, including the ETAC process and the IRP. And then this is an integral part of his testimony, to which the joint applicants did not lodge any objection until now. They've had this since March 16th when it was submitted. The date in the timeline describes the action and the relevance to the merger context. This again is a core part of Mr. Schneider's testimony, and why this unfolding of the merger process is integrally related to the Colstrip issues, the FERC docket, the ETAC, the IRP, and the large load tariff. And excising it would be as if just taking out half his testimony. And if we need to go through a Q&A on direct testimony and develop the foundation for it, I can certainly do that now and take the commission's time and do all that. But this is a timeline. It's part of his testimony. It belongs in the record, and we ask that it be included.
Ms. Norcott?
Thank you, Madam Chair. Ms. Trinnell just made my point. We are not objecting to his testimony. We are objecting to the exhibit. The exhibit is cumulative and misleading. It's improper summary under evidentiary rule 1006. Again, the testimony is fine. The exhibit is not. Furthermore, we did identify this as an objection in our pre-hearing objections filed on May 6th.
Yes, I do see that. Thank you.
I would just add that the joint applicants are welcome to cross Mr. Schneider on any of this.
Thank you. Give me a moment. Ms. Norcott, you've asserted that this timeline is misleading. Can you please elaborate on that for me?
Yes, thank you, Madam Chair. So this timeline is misleading in the fact that it's conflating the issues before this commission relative to this merger. This timeline talks about lots of things, IRP planning, the Colstrip, Puget 370, FERC filing. It's just conflating the issues, and I think it causes confusion for the commission as it relates to the merger before this commission. It also offers argument about the contents that about the contents of the documents themselves.
Response.
You may.
They don't like the way it's laid out. They don't like the interpretation of it. They can cross-examine and make their arguments and tell the commission the story they want it to, they want the commission to hear. This just says, here's what happened. Here's when it happened. Interpret it any way you want to, but the fact that it happened in this order on these days, and these are the events that happened, they're not saying we lied about what happened on what day. They don't like the way it reads.
Thank you.
And that's for the commission to decide.
All right, and to be clear, we're talking about exhibit MT 350 or 350 MT exhibit 43 with exhibit 21, which is the timeline. Is that correct?
Yes, and which is embedded within the testimony and paginated as part of the testimony, 19, 20, and 21 as pages.
Okay, and joint applicants didn't object to 43. They were objecting to the inclusion of exhibit 21 within it. Is that correct?
Madam Chair, that's correct.
Okay. The objection is overruled and 350 Montana 43 with exhibit 21 is admitted.
Thank you, Madam Chair. Joint applicants also object to the omission of 350 Montana Exhibit 22. This document appears to be minutes from a Electric Technical Advisory Committee of Northwestern from October 29th of 2025. Review of these minutes, the commission will see that it has to do with modeling of in the IRP for the Colstrip acquisition and specifically Puget. That issue has nothing to do with this docket. That's more appropriate for an IRP docket, so we object on the grounds of relevance.
Okay, and restate the exhibit you're objecting to.
350 Exhibit 22.
I don't think Ms. Trinnell moved 22.
I believe, Madam Chair, it's embedded within 43, which is Mr. Snyder's cross-intervenor testimony.
Okay, Ms. Trinnell.
I'm happy to lay the foundation asking Mr. Schneider about this. The ETAC minutes from October 29th, 2025 are referenced throughout Mr. Schneider's testimony, and the relevance to this docket is that the Northwestern executives directed the team, the IRP modeling team, to take Puget out of the base case scenario, which Mr. Schneider speaks to in his testimony and should be the one talking about. But these exhibits are relevant to how that Puget share is handled and why that $0 acquisition is going to serve data centers and not the Montana captive customers, why we're paying for the most expensive share of Colstrip, and Meta and Microsoft are getting the $0 acquisition share of Colstrip. That's what these minutes go to. Mr. Schneider speaks to that and how the commission treats Colstrip as part of the merger docket and whether it imposes conditions are before the commission as part of this merger. And these minutes establish that foundational piece of what was going on. This happened the same month the merger docket was filed.
Thank you. Ms. Norcott.
Madam Chair, we stand on our objection on the grounds of relevance.
All right. The commission finds that 350 Montana laid some preliminary foundation on this exhibit. 350 MT 22 is admitted.
Thank you, Madam Chair. We tender Mr. Schneider for cross-examination.
Okay, is there a cross-examination for this witness?
Madam Chair, no cross, but I reserve the right for recross after commissioner questions.
You always have that right.
Is that how the process works? That is not what we have been allowed to do. If we didn't ask cross, we were not given the opportunity to do recross.
No, I think my recollection of our process is that after commissioners ask questions that parties can recross
It's
based
fine.
on those
It's fine.
questions.
It's fine.
Okay. Pardon me?
No objection.
Okay, thank you. Okay, are there commission questions for this witness? Commissioner Molnar?
Thank you, Madam Chair. Mr. Schneider, just for the record, we know each other. We worked here for 8 years together.
Not quite that long, Commissioner, but we worked together, yes.
It seemed longer. Can you give us a brief overview of what you did after that in the regulatory regime?
Yes, when my, excuse me, when my term expired in the end of 2006, which was the period of time we were on the commission together, I moved to the Western Electricity Coordinator, Western Electric Coordinating Commission Council, and spent 7 years there in various managing director commissions, positions with WEC. Reliability standards, long-term transmission expansion, transmission planning, and regulatory compliance, corporate compliance.
Thank you. Have you been with 350 the whole time that this case has been evolving, or did you come on recently?
I came on just in time to file direct testimony on February 9th.
Thank you. In your experience, which is pretty vast, do we have a body of evidence to go forward and come up with proper conclusions, or is there going to have to be a need to augment?
Sorry, Madam Chair. Objection calls for a legal conclusion.
Sustained.
Actually, I'm asking for a professional conclusion.
And the question was directly predicated with the in your experience. I think the witness can speak from his experience to the question that was posed.
From his experience, yes, but a legal conclusion, no.
That wasn't the question. The question was in your experience, and I think Mr. Schneider can speak to that.
Ms. Norcutt.
I'm sorry, Madam Chair. There's a lot going on. 1 minute. Madam Chair, that goes to the ultimate conclusion for this commission to decide, which is whether or not there's sufficient evidence
Well,
to meet the approval.
Okay. From that standpoint, overruled. I think Commissioner can ask the question.
Thank you. Please answer the question, Mr. Schneider.
As
Just one moment. My counsel's flagging me to hold off on this for a moment.
could I get some water? My voice is gravelly enough. Thank you very much. I appreciate that.
I'm sorry.
All right, Commissioner Molnar, you may proceed and the witness may answer the question.
Do you remember the question, Mr. Schneider?
Could you try it again, Commissioner?
I'll give it a whirl. Mr. Schneider, in your experience, I'm sure that you've gone through many evidentiary processes to come to conclusions. Do you feel, in your professional experience, that we have an evidentiary base that will allow us to come to a proper conclusion?
Commissioner, what I have filed here and what we have been discussing for the last few minutes is cross-intervenor testimony. So I filed testimony on February 9th, direct testimony. After reviewing the submissions of the other interveners, the opportunity was afforded under your schedule for cross-intervenor testimony. What I saw in the record at that time did not address the issues that I thought were critical in terms of providing the commission the big picture as well as the details related to a decision and a application of this significance in Montana. So the bulk of my testimony is directed directly at that additional issues that needed to be available in evidence to the commission for them to have a comprehensive record. And that is my testimony. And I detail additional elements, and the commission is very familiar with directing parties to address additional issues that you want addressed. I did that as an intervener, seeing a record that had not addressed issues that I thought were critical. So
thank you, Mr.
that's
Chairman.
my response.
Madam Chairman, Mr. Schneider, since you filed, have you changed your mind on what might be lacking? Has something been filled in for you? Are you more comfortable or about the same as you were when you filed?
The issues that I raised, the additional issues, are core issues to the whole ability to review this proposed transaction, just in the same way as the big picture issues I've talked about here were of interest to investors in the investor calls. They need to have due diligence with a fully developed record, just as you do, in order to make this significant decision on the big public policy issues in this merger.
Thank you. To shift gears for a little bit, Madam Chair, Mr. Schneider, I didn't catch all of it. Perhaps I didn't read enough to get here, which is highly probable. The last thing that was discussed, and I believe it was concerning your testimony, was on the FERC filing and the 380 being filed on this, being handled the same day to supply Meta and another data center. Can you elaborate on that for me, please?
Objection, misstates facts in the evidence regarding Meta being served.
Whoever he mentioned is what I'd like, whatever that last reference was. Can you tell me what the Monday, as to how that got filed the same day or handled the same day as the filing? Am I stating that correctly? Because it really took me right upside the head.
So with that rephrase, is the objection withdrawn?
Yes, Madam Chair.
Thank you.
So the discussion that Joint Applicant Council had about the timeline was the context. The timeline that I presented in my testimony gives context to the sequence of events that included the removal of Puget 370 from the base case of the integrated resource plan. It involved the assignment of that 370 share of the Puget resource to the unregulated entity outside of the ring fencing of the commission in the unregulated affiliate. It involved the filing then of the application with FERC for approval of a tariff for competitive supply. All of those things and more, as described in my testimony, happened in a relatively short period of time. That gave me great pause. The other thing that is closely related to it in the testimony and on that timeline is the sequence that involved the commission staff's inquiry about that exact issue. They, on November 5th, commission submitted a letter to Northwestern about what's going on here. How did this occur where you are now treating and have assigned 370 to an unregulated entity and petition for FERC rate treatment, tariff treatment of that when we thought it was in? The response to that is extraordinarily important. That is their response on November 11th, 2025. Key to my testimony, and much more importantly, key to your consideration of how that whole zero investment 370 megawatt coal strip share is treated. And there has been extensive discussion in the course of this hearing about the disposition of that 370 megawatt share by Mr. Byrd and others. So this sequence, and the reason that I put in the timeline, was to try and make sure that the context and the timing and the perspective was available to the commission.
Mr. Snyder, I appreciate everything you just said and the candor that you brought forward. Last time I saw you, you were the smartest man in the room. You still are. Thank you, sir.
Other commission questions for this witness? Seeing none from my colleagues, I've got a couple. Thank you, Mr. Schneider, for being here through this. So I'm inferring from your testimony, your pre-filed testimony, that, and particularly your timeline, that you believe the assignment of coal strip 370 PU by Northwestern to this unregulated entity, you believe that's related to the merger, it's connected to the merger?
Absolutely, as we've seen throughout this testimony in terms of their ability to serve going forward. It's tied to the integrated resource plan. It's tied to the merger. They are all very important dimensions, and the large load tariff, I might add. They're all part and parcel to understanding how this merger will go forward and the effect on captive ratepayers. It needs to be looked at simultaneously. So now we do have, at long last, a large load tariff filing on the last day of March. That's a very important, good development. Whether the merger goes forward or not, that needs to be in place. Similarly, the integrated resource plan has now officially been filed, which provides the foundation for the whole assessment, whether the resource is needed. It is, for example, the Puget share is included in every scenario that involves data centers. It used to be in the base case. It was part of the base case. It was removed at the direction of management.
The Puget share you're speaking about.
Excuse me?
You're speaking about the Puget share.
I am. The
Okay.
370 Puget share.
Okay. And is there any possibility that the Puget 370 share was placed into this new subsidiary of Northwestern Energy Group for reasons that might not have been related to the merger?
Anything's a possibility, but the timing is all tied together.
I see your
Madam
point
Chair.
about the timing. I do see your point about the timing. Did you hear Mr. Bird's testimony?
Word for word.
Okay.
I listened with great interest.
Okay, so did I. And I believe he testified, and I'll ask you if this is what you heard, that, and you mentioned the Public Service Commission's letter in November to Northwestern Energy about what are you doing with this transaction regarding PU 370, and then Northwestern's response to that, saying they believed we didn't. Well, I won't say what they said because I don't have it in front of me, but you're aware of their response. And then Mr. Bird's testimony this week was different than that response from Northwestern that we received last year. Do you recall the difference?
What I recall pretty vividly, just in immediate response, was his discussion with, I think, Commissioner Pinocci and Commissioners Molnar about the treatment of that 370 zero investment share.
Okay.
And the possibility and timing of the return of that share to potentially serve customers, large customers, and data centers.
And do you remember him agreeing with Councilor Turnell that that could be a condition of the merger, would be to return 370 PU 370 back into the regulated utility if and when that resource was needed to serve Montanans?
I listened to that very carefully. I think that's an important step. What I would also add, it is directly in my recommendations on additional concessions or conditions that the commission ought to include if you can continue forward with the merger. It's one of the minimum conditions that I recommended.
Okay, thank you. That concludes commission questions. Council, do you have any questions?
Just as a matter of housekeeping, Mr. Schneider, you filed direct and cross intervener testimony in this matter, correct?
Correct.
And it's my understanding that the cross intervener testimony was submitted on March 16th.
Yes.
Okay. Did you review any of the materials that were submitted in the docket on March 4th and then going forward?
I hope that I've reviewed everything from March 4th forward.
Can I
Were you asked to provide testimony on the confidential material that was disclosed on March 4th?
I haven't been involved in any, excuse me, that's a clarification, I guess. I have not signed a confidentiality agreement. As a matter of principle, I just don't do it.
Okay.
So I haven't seen none of the confidential information. I didn't want to see it, and I haven't seen it.
Thank you. That addresses your point, Counselor. Okay, thank you. Now we're finished with commission questions. We will go to recross based on the commission questions.
Thank you, Madam Chair. I have just a few.
Okay.
So just to follow up on Ms. Snyder Barnes' question about your review of the evidence in this docket. If I understood correctly, you have not reviewed all of the evidence that's before this commission for consideration of this docket, correct?
As I just described, I have not reviewed any of the confidential information provided in the docket.
So it would be correct that you have not reviewed all of the evidence that is before this commission.
That is correct.
Okay. And regarding Colstrip 370 PU, you would agree that is a FERC regulated asset at this point, correct?
Yes, and it is under contract and approved for a 21-month period through Mercuria, its contract with Mercuria.
Okay. So besides speculation on the timing that's in your timeline exhibit 21, do you have any actual evidence to support that the treatment of Puget was in some way connected to this merger? Do you have any actual evidence to point to?
What I would point to is that the discussion with Mr. Byrd about his familiarity with the letter of November 11th that he said he would have to review the details of, but he was very familiar with, is really, you know, one of the links that I would respond to in terms of saying this is related directly as the IRP and the large load tariff issues. They're all related. So I don't have anything that says on August 29th that the Puget sale that occurred or assignment that occurred in October was related to the merger.
Thank you. Madam Chair, if I just might have a moment to confer. Madam Chair, I have no further questions for this witness. Thank you.
Okay, thank you. And redirect. Ms. Trinnell.
Thank you, Commissioner, Madam Chair. I have just one, and it is this. Mr. Schneider, based on the commissioner questions and the follow-up cross from the joint applicants, is the siloing of these dockets part of the problem before the commission right now?
It's my opinion, Madam Chairman, members of the commission, that, and I think Commissioner Pinocci was very clear about that as well. The segregation of the large load tariff, the integrated resource plan, the merger, the assignment and disposition of the Colstrip shares, the large load tariff, and the integrated resource plan are absolutely tied together in every way. So as you know, and I accept as genuine, you are trying to separate merger issues from other issues, I will say. I term those additional issues that the commission has dealt with frequently as a regular practice. So I have struggled throughout the proceeding, as I think even you have, in terms of, okay, we've got merger on the bottom of this document. It can go in, even though it's contextual wise, deals with a bunch of other things. So, yeah, I honest to goodness think it needs to be considered simultaneously in a comprehensive way, just as the investment community wants to look at it. I mean, I have pored over those transcripts from the August 19th merger conference and as late as the latest first quarterly filing, it is absolutely loaded with questions about each and every one of these related issues. They want to understand how this is going to work under this merged entity. Their questions are very direct. The responses are I think, very enlightening. And I've spent a whole lot of time on those transcripts from those investor conferences. I spent a lot of time on the March 11th letter and what ramifications that has. I've been through the large load tariff in detail and all of the supporting testimony related to it. There are issues related to, I'm dang glad they filed them. Darn glad that they filed the large load tariff and the integrated resource plan. They now need to be updated. Let me give you a real direct example.
Madam,
Yeah, I think I know what you're going to say. And if you could, Mr. Schneider, just answer your counsel's question and refrain from a full narrative at this point, that would be great.
I apologize, Madam Chairman.
Thank you.
Just one more. Do you have an example, Mr. Schneider, of what you were just talking about?
Madam Chair, I'm going to object. He just gave a 2-minute explanation answering her question about the siloing of the dockets. He mentioned the large load tariff. He mentioned other things. I feel like that's already been asked and answered.
Counselor.
The questions, do you have an example?
Yeah. Overruled. Go ahead, Counselor.
Thank you, Mr. Schneider. Do you have an example for the commission?
Yes, this should not be argumentative, kind of an example. The large load tariff relates to the proposed service of loads above 5 megawatts, including a special provision for large loads greater than 50 megawatts. And the filing in the large load tariff is clear that it is intended to serve not only data centers, but also returning large customer group choice customers that have been in the competitive market since deregulation. Okay. Those potential large customer choice loads have not been included in the integrated resource plan. And we attempted to ask Mr. Merkel yesterday, a perfect witness to ask this, whether what was the magnitude of the potential returning choice customers that were not included in the existing IRP that he talked about in his testimony.
Madam Chair, I'm going to object at this point. He was asked for an example. He gave an example. I feel like now he's going into narrative and totally outside the scope of this merger.
Counselor.
Well, I guess that remains for the commission to decide. I don't have any further questions
Okay.
at this point.
Thank you. Sustained, and without any further questions, then would you like to ask your witness to be excused
I would. Madam Chair.
temporarily?
Well, I think we might be done, I hope. But
Is there any objection to excusing this witness permanently?
No objection.
Okay, thank you, Mr. Schneider. You're excused permanently.
Thank you. I haven't met all of you, so it's an honor to be here.
Thank you for coming back.
And 350 Montana rests.
All right, well, good. So I think this means we go back to the joint applicant's rebuttal case.
Yes, Madam Chair, if we just may have 30 seconds to confer with our client to see whether or not we have anything to, for rebuttal.
You only want 30 seconds?
Okay, Madam Chair, I've conferred and we have no intention of calling a rebuttal witness.
Okay, very well. Yes, it is. All right, so we will go ahead and move to brief closing statements, and we are going to keep these brief. It's been a long week, and so if we can, let's try to stick to about 5 minutes. You can reserve your, what, is that too tight? 10 minutes. So do the parties wish to present a brief closing statement? And then we'll start with the joint applicants.
Thank you, Madam Chair. If it'd be okay, I'll present first on behalf of Black Hills Corporation.
Okay, go ahead.
So, Madam Chair, President Wellborn, Commission, and staff, just a few closing comments, and then I'll turn it over to Mr. Green for comments from Northwestern Energy. First, we just want to thank the Commission and the staff for all their efforts in this case, for making this hearing possible. We really appreciate all of that. And over the last few days, you've heard a lot about the potential standards for approval, but this commission has set a clear standard for approval under these facts. Where adequate service is not at issue, the commission applies the no harm and public interest standards. And this merger of equals meets those standards. As you've heard, there will be no rate increase as a result of the merger. The commission will continue to regulate 100% of the Montana utilities, Northwestern Energy Corp. And its assets throughout the state, and Black Hills Power, just as it does now. That's 100%. These two reliable Montana utilities will continue to provide quality services throughout the same systems by local employees. And the merged entity, Bright Horizon Energy, will ensure the Montana utilities will be fit, willing, and able to serve, which is what you'd expect when two excellent companies come together. And not only are Black Hills and Northwestern Energy natural merger partners, they've also worked with a variety of Montana interests, as you've heard in this hearing through the last few days, so that this merger will make sense for all of them. We've heard from the Montana Consumer Council, which represents everyday Montanans. We've heard from the Large Customer Group, which represents business interests. Labor's International Union Local 1686, which represents the men and women of the construction industry in Montana, as well as the city of Missoula, the county of Missoula, and the combined interveners who appeared as the joint energy advocates. This is a wide array of Montana interests, and you've heard from them directly. And all of these settlement parties have resolved their concerns and their opposition to the merger. Only 350 Montana and the Montana Farmers Union oppose at this point. And you've heard many things from them, but nothing they have said stands in the way of the commission approving the merger. They argued the merger will result in less oversight from the commission, but the commission will retain 100% authority over the same utilities before and after the merger. They've claimed the merger will result in a loss of profits or control, but the ring fencing applicable to Northwestern Energy Corporation protects Montana customers. They've complained that Black Hills multi-state footprint, but Black Hills experience has taught it the importance of local management, local input, and community involvement. And they've claimed the commission does not have the necessary information for approval, but joint applicants have established a full evidentiary record with all of the facts and legal requirements for approval and more. After all that's been presented at this hearing, one thing is clear. This merger is good for Montana customers. It will do no harm. It is in the public interest. And for all these reasons, we ask the commission to approve all settlements, reject the objections of non-settling parties, and approve the merger in this docket. We thank you for your time and consideration, and I'll turn the time over to Mr. Green.
Thank you, Mr. Barker. Madam Chair, with your permission, Ms. Norcott is going to hand out just a copy of an exhibit that's already in your binders, but just for your convenience. And we'll provide a copy to council as well. Madam Chair, Commissioners, we've covered a lot of ground this week, and we really appreciate you allowing us a brief moment to conclude the hearing. We want to talk to you about what the commission's role is in this proceeding, what the merger is, and why the commission must approve this merger. So first,
I've never seen this exhibit before. Where is this?
This is Exhibit B to the settlement agreement
Okay,
between the
thank you.
Montana Consumer Council and the large customer group.
Thanks, Mike.
Madam Chair, the commission's role in this case and the question you have to answer is actually very narrow. And that's whether the merger of two utility holding companies at issue here will cause harm to Montana customers and whether it's in the public interest. Now, we've had a lot of objections here, and we've tried to keep the record confined to those issues. That doesn't mean we don't think those issues are important. That means we don't think those issues are relevant for this matter. And they don't matter for this because I've put in front of you the exhibit, which shows in the ring, in the red box on here, this is the Montana utility. This is Northwestern Corp doing business as Northwestern Energy in Montana. This is the entity that you have jurisdiction over. You don't have jurisdiction over anything outside of that box, and this transaction is occurring outside of that box. So your role is to make sure that what we're doing outside of this box does not impact the customers that we're serving inside this box. The testimony that you've heard this week, the settlements that we put in front of you all demonstrate that there is absolutely no harm to the customers inside this box that you are responsible for protecting. More importantly, it demonstrates that immediately upon execution of this merger, there's going to be $10 million of financial benefits that will flow to all of those residential customers, your constituents. More importantly, what you've heard this week is that over the long term, we're going to see substantial benefits from the efficiencies, the scale, the size, and the experience that are being brought to bear in this case. Madam Chair, Commissioners, when we slap this up on this same structure, that box follows us. Nothing that happens above Northwestern Energy Group impacts your authority at all. You still have authority to investigate the coal strip docket. You still have authority to review our IRP. You still have authority to review our rates, and you still have authority to review our large load tariff. There is nothing in this merger which impacts your ability to do your job. We've talked a lot about obligations of boards of directors and management. You met our managers. You've known two of them for years. And I hope that you didn't have a chance to talk to Ms. Nooney very much, but I hope that you were impressed with Ms. Jones and you've seen what this leadership looks like, their commitment to their customers. You heard Ms. Jones talk about our stakeholders are our shareholders, our customers, our communities, and our employees. This is not a shareholder-driven matter. Our shareholders certainly believe this is in their best interest, and they voted overwhelmingly for this. We've been accused in this in this proceeding of telling you something different than what we've told our investors. I'd ask you to go look at the proxy. It's been entered in as 350 Exhibit 31A. Go look at that proxy statement. Now, don't wink and nod and close and just look at the one cherry-picked statement out of that document. Read the whole merger justification. It talks about value. It talks about our customers. It talks about our employees. It talks about expanded expertise. Now, I don't think this was her intent, but I was happy that Ms. Trinnell brought this board. Some may look at this and say this is a complex corporate structure. It's confusing. When I look at this like an NBA coach. This is a deeper bench. This is adding centuries of experience, of energy and utility expertise to help serve Montana customers. We have access upon completion of the merger to all of that knowledge, expertise, size, scale, and resources. That is a direct benefit that will pay dividends in the long run for all of our customers. Some of you have asked during this, let me step back. We recognize this is an historic decision. We've heard these don't come along very often. This isn't Sleepy Hollow. This isn't Energy West. This is a big damn deal. And we recognize that. It's not a hard decision. And it wasn't a hard decision for our shareholders. Now, we recognize the long shared history that we all have in Montana. I'm a fourth generation Montanan. I'm a lifetime resident of Northwestern Energy service territory. I've bounced around a lot. I recognize the fears and the concerns that all of you are dealing with from your constituents. But Mr. Smith, I think, said it well. He's been here a long time. He's represented consumers in Montana for a long time. They looked at this. They raised their concerns. They got comfortable with it. They negotiated resolution to us. They preserved ring fencing, and they are confident that we have protected utility customers in Montana as much as possible. Very briefly, I want to reiterate our appreciation for the time and attention for all of you this week. We recognize the time that you've committed before the hearing, your staff has put in during the hearing. Especially want to call out Ms. Lasowski and her valiant colleague for their court reporting skills this week. But I also want to thank the company leaders who appeared before you today. I hope that you found them as credible as we do. And I want to thank this incredible team who helped us put this case on in front of you. Commissioners, some of you have asked this week, what do you tell your constituents about this merger? And I want to help you with that. You can tell them, I, Commissioner, spent 3.5 days looking the leadership of this new company in the eye and asking them tough questions. Now, we all agree that we are facing record energy demands in the future, and I think that team that I saw and questioned can help us meet those demands. You can tell them this merger is going to create a stronger support system and help Northwestern be more efficient and resilient and to best meet whatever challenges we're going to face tomorrow. Montana is not going to lose a thing because our local utility operations are not changing unless we can figure out a way to do it better. You can say that the commission is not giving up any of its control. So you and the rest of the commission are going to be keeping an eye on us. You're not giving up anything. We're not transferring assets. We're not canceling contracts. We are keeping our assets. We are honoring our contracts, and we are serving our customers today, tomorrow, and the next day. Commissioners, I urge you to approve this merger. And I assert that you can confidently tell your constituents that after carefully considering the full record in this case, you believe the leaders that you saw here today when they say we truly are better together. Thank you.
Thank you. We will now go to closing brief from 350 Montana.
Madam Chair, I'd like to present from the podium if I may, and then I'm going to pull these two exhibits over. Capital is not finite. Capital is not finite. You heard those words here from the people who want you to approve this merger. For whom is that true? Is that true for anybody you know? Is that true for any one of your constituents? You know who it's true for? Meta. It's true for Microsoft. 200 million for a generation reservation agreement, no problem. See if you can go pick me up that plant in Colstrip. Maybe turn it into nuclear in 5 years. You know how many billions of dollars I'm going to make in annual revenues? Who says capital is not finite? The people who came here and asked you, this commission, to sell Montana down the river. We have been here before. We have seen this movie, and we know how it ends. Chris Ellinghaus called you, the Montana Commission, the big enchilada. You are. You are all that stands between Montana and selling us out to people for whom capital is not finite. There are a lot of people who haven't been here. There are a lot of people who don't know this merger is happening. They're at work. They are the salaried employees making maybe $15 an hour, for whom $16 million is a lot of money. That might not be a lot of money for the people who are trying to ask you to approve this merger. That's a lot of money to the people of Montana. So please, please take careful care with the evidence that has been brought here this week. And now let's look at what is here and what's not here. Look at what happened just now. They say, oh, let's just cover up this chart. This represents the entire story that's going on here right now. Don't look. Don't look at what we're telling our investors. Oh no, Mr. Regulatory Body of Montana, you just look at the little thing that we are asking you to look at. Don't look at this whole chart. Just look at this. You still retain your regulatory authority over Montana, but look who you lose it to. An NBA coach with a lot of players? Sure. Guess who gets salaries and needs to get fed and needs to get housed? All those people fighting for capital. And guess who decides where it goes? Not us. Not Northwestern. And you lose control over those dollars and where that money gets spent. That's what they're asking you to do here. So what's in the record and what's out? What's in the record? Data centers. Objection, objection. Let's count how many times we got that word. But on every document, underneath merger is data centers. And when Mr. Green asked you to look at that document and read it, whose exhibit was it? It wasn't theirs. They kept it confidential. It was until we asked that it became public. February 6th, they filed it as a public document after holding it confidential for 4 months. It's our exhibit. It is before you because we put it before you. Look at that. That's what we put in the record. Look at the whole record. Look at what they told investors over and over and over again. Look what's in this whole record. These dots in this record, they are big and they are close together. Colstrip connects to Gillette, connects to Cheyenne. And where does it go from there? And who stops the next move? Nuclear, windmills, all over Montana, whatever they want for people for whom capital is not finite. Whatever they want, who stops them? You do. Here, now, today. And look at the record, look at the whole record, and look at what's not in it. When we opened 4 days ago on Tuesday morning, we told you at the end of this case, we told you what wouldn't be in front of you, and it's not. The record does not contain the large load tariff. They fought to keep it out. The record doesn't contain final ESAs for large load customers. It doesn't contain final cost allocation for transmission, interconnection, generation. It doesn't contain a final post-merger cost allocation manual. It doesn't contain an integration plan. It doesn't contain quantified enforceable customer savings. The record does not resolve how Colstrip 370 PU will be treated. Absent those things, this commission should not and cannot responsibly hand over its authority over what for us in Montana, for the people for whom capital is finite. Do not hand over your ability to set rates for our utility. Don't accept promises. This is not a place for hopes and dreams. This is a place for boring numbers, for you to do right by your constituents, for you to go home and say, I voted against that merger because I understand that for you, for us, capital is finite. And I killed that merger to protect Montana and so that you can tell your kids and you can tell my grandkids that when we had another chance to sell Montana down the river, you are the proud people who sat in these seats and voted no. I am asking you to reject this merger. It is bad for Montana. It is bad for everyone for whom capital is finite. Thank you for listening.
Thank you.
Madam Chair, may I have a very brief rebuttal?
Mr. Green.
Madam Chair, Commissioners, in my short time at the company, I've been here for a year. I celebrate my 1-year anniversary next week on Tuesday. We have been repeatedly criticized for filing overly complicated and complex cases in front of this commission. We now file a case that's very simple, addresses the one issue that has one legal threshold, and now we're getting criticized because we're not addressing everything related to utility regulation in the state. We can't win. Madam Chair, Commissioners, Ms. Trinnell's own witness today said this merger does not impact the commission's authority over the Montana utility. That's all you need to know. That's the ballgame. You have all the authority you need to resolve all of those other issues that Ms. Trinnell just addressed, and we look forward to debating those before you and your consideration of those issues, and we really appreciate your time this week.
Okay. All right, thank you, counselors. Thank you to the witnesses. Thank you to the staff support that we've had, and all the commissioners for your attention to this. We are going to go to a brief scheduling conference for maybe 5 to 10 minutes for attorneys to confer on the schedule. And then we will come back on the record to announce the results of the scheduling conference and read those into the record. Commissioners are welcome to stay for that if they want, but we're not expecting any substance at that point, just scheduling matters that the parties agree to. So with that, we will go off the record for a few minutes. The time is 2:59. Please be back here within 10 minutes. Okay, before we go back on the record, we're still doing a off the record attorney conference, and we've got the Zoom feedback on. So Mr. Lowney, Mr. Brown, and Mr. Stoffel, if you want to unmute yourselves, you can hear what council in the room have proposed, and we'll see if that works for everyone. So council in the room for 350 Montana and joint applicants have agreed for the opening briefs to be June 5th, the reply to be due July 2nd, and an optional reply from joint applicants on July 13th. Is there concurrence or any objections from Mr. Stoffel, Mr. Brown, or Mr. Lowney?
No objection.
No objection, just a question for clarification. Given the settlements, are the settling interveners expected to file on the opening deadline or the response deadline?
So it would be joint applicants on June 5th, interveners settling or otherwise on July 2nd, and then a reply on July 13th. And essentially, this just extends the response briefs due and the reply from June 26th to July 2nd, and then July 6th to the 13th, respectively. But yeah, the interveners settling or otherwise is considered the response brief. Mr. Brown's suggestion was considered, but not ultimately adopted.
Thank you for the clarification. No concerns with the proposed schedule.
Thank you.
No objection from the city of Missoula.
Okay, thank you. You ready to go back on the record? All right, the time is 3:17. We are back on the record to announce the results of the scheduling conference. The time I said is 3:17. The results of the scheduling conference will now be read into the record by our staff attorney.
Thank you, Commissioner Fielder. After discussion off the record with respect to the post-hearing scheduling, the opening brief of the joint applicants will be completed by June 5th. The response briefs by interveners, settling or otherwise, is July 2nd. And the reply brief would be July 13th. I should note that the court reporter has stated that the transcript, both a confidential version and a non-confidential version, will be available about Tuesday, May 26th.
Thank you.
Point of clarification, Madam Chair.
Yes.
And Pam, I just want to clarify, the reply is for the joint applicants only. Is that correct?
Yes, the reply is for the joint applicants.
Thank you.
All right. With that, are there any other questions? Well, excellent. The evidentiary hearing is now closed.
No.
Wait, why not? No. The
Thank
final
you.
comment period is open. The time is 3:19. And the public comment period is open. So are there any public commenters in the room? Are there any public commenters in the room? Seeing none, are there any public commenters online? There are no public commenters online. Seeing none, we will now close the hearing on this docket. Anyone wishing to follow the outcome of this matter may follow docket number 2025.10.078 on the Commission's online ready portal. Please contact the Commission at 800-646-6150 or email pschelp@mt.gov with any questions about accessing the portal or subscribing to notices of filings. Thank you to everyone who participated in this matter. The time is 3:20 p.m. The date is Friday, May 15th, and the hearing is now adjourned. Thank you. We are off the record.